Good morning all. We're here for a hearing on the matter CFI 28-2016 before His Excellency Justice Shamlan of Sawalehi. The claimant is represented by Al Tamimi and Company. Lead counsel is Tom Montague Smith QC. Assisting is Peter Smith. The defendant is the litigant in person. The lead counsel is Rory Brown.
I think Aisha would need the rule book. I'm not sure this one is updated. Well, I'm just waiting for my rule book. I thought it's going to be a copy here, the updated one. I went through all the file, all the document, but not all of the authority being filed by the parties. I went through the skeleton argument. I have a good understanding of both side argument and submission. Before the applicant starts its skeleton of argument, it's very important for me to be directed where the legal representative of the claimant, of the applicant, will be focused in which part of the ground to set aside the default judgment, and in particular whether we are dealing with the ground where the court must or the court may set aside the default judgment. Then we'll take it from there. Of course, then we'll listen carefully to the respondent and his position, and we'll went through all the supporting document on both sides. So the floor for you.
Your Honour, I'm very grateful for that indication. May I check that Your Honour has received, in terms of the documents, skeletons from both sides and authorities from both sides?
Yes.
I'm most grateful. I shall come to the rule, if I may, a little later on, and I shall make abundantly clear the ground on which this application is made, so Your Honour need have no concern there. If I may ask the Court's indulgence just for one sentence before I begin the application, just to say that this is my first appearance in this tribunal, and I want to say that the experience of my clerks and of myself, of the administrative staff, both at the registry and the academy, has been that they have been extremely welcoming and very professional in facilitating me appearing here today. So, this is an application to set aside a judgment in default. Your Honour has a discretion. The rule, so there's no doubt about it, is this. The Court may, on such conditions as it sees fit, set aside or vary a judgment entered under Part 13 if either 1, the defendant has a real prospect of successfully defending the claim, or 2, it appears to the Court that there is some other good reason why the judgment should be set aside or varied, or the defendant should be allowed to defend the claim. Now, in the course of my submissions, you'll see that I'm actually going to approach that backwards, in that I place considerable reliance on there being other good reasons. And I say there are 3, as you'll have seen from my skeleton, Your Honour, 3 other very good reasons for setting aside this judgment in default. If I'm wrong about that, which I'm not, I then say that it's blindingly obvious that the defendants have a real prospect of successfully defending the claim. But so there's no doubt it is accepted, and therefore it's not an issue, that service was affected according to the rules in Jersey. So this is not a case where I can turn up and simply say, Your Honour, you must set this aside.
So actually we are dealing with Part 13, 14.2 in this case.
Exactly so.
Oh. Well noted.
So in terms of the structure of my submissions, what I'll do first is just set out the chronology, very briefly, of the 4 sets of proceedings here, so that they're clear in the court's mind. I'll then deal with the 3 good reasons I say you have for setting aside. Then I'll deal with the real prospect of success, limb. Then I'll come on to subsidiary issues, I say, of promptness, whether I've made this application promptly. And then the question of indemnity that my learned friend raises at the very end of his skeleton argument. So in terms of the chronology, you'll see when these companies were set up. The first key event is the revocation of the power of attorney in May 2014.
Yes.
Now, Your Honour may have seen from the Jersey judgment that the power of attorney was granted by Ruzin Al-Chimar, Ms. Al-Chimar, who is the director of the companies, to give general authority to the claimant, Mr. Al Tamimi, to act on her behalf in relation to those companies. The next key date is July 2014, when the loan contracts, pursuant to which the default judgment was entered, were produced. In a year later, or almost a year later, in May 2015, there was a petition in London based on the loan contract in relation to Jorum only, so just one of the companies, to wind up Jorum based on the loans. And the loans are the same loans that are in issue in these proceedings. I don't know the issue date of the Jersey proceedings, but the amended claim form in the Jersey proceedings is dated the 2nd of July 2015. So it came shortly after the petition in London.
Yeah.
Okay. The following year, almost exactly a year after the petition was presented, it was dismissed. And it was dismissed at the final hearing of the petition on the application of the claimant, Mr. Al Tamimi. He made an application to adjourn, which was dismissed. His lawyer, Mr. Perkins of South Square, then went outside and came back in and said, I'm applying to dismiss. And of course, I was representing Jorum, so I said, well, that's great news. I'm applying for indemnity costs. This was an abusive process. The judge, agreeing with my submissions, awarded indemnity costs on the footing that it is an abusive process to present a winding up petition in respect to the company where it is known to the petitioner that the debt is disputed. So, just to be clear, that was the same loan as the loan in respect of which the claim is brought, but only in relation to Jorum. On the 24th of July 2016, the DIFC claim, the judgment of which I'm asking you to set aside, was issued. On the 3rd of August 2016, there was service of the DIFC proceedings on the company's agents, STM, in Jersey. And when I say the companies plural, Jorum and First Grade. As Your Honour might have seen from the papers, the claim that was served was then sent back to Rachel Wunsch, who's an agent of the claimant and was a director of the companies. She had known at that point, I'll come to this again later when it comes to service, that she had been removed as a director. She had known that from May 2015 on her case. And of course the power of attorney, as I mentioned at the outset, was revoked in May 2014. Those proceedings were not forwarded to my client. What I mean by that is that there is no evidence that STM forwarded the served proceedings to the director of the companies. that is to Mizar Chular. And as Your Honour will have seen, these companies are not companies with multiple staff. They're special purpose vehicles for the purchase of property in London. They can only act through Mizar Chular. On the 10th of October 2016, the trial in Jersey began, and it went on for 7 days. And at that trial, all of the documents in relation to the loans and the company's records were before the court. Mr. Tamimi gave evidence himself. His accountant gave evidence. Ms. Wunsch gave evidence. And they gave evidence on the loans. And that's of particular relevance to the application before you today. The Jersey judge, I think then after that, the commercial court proceedings, so the fourth set of proceedings in London for the enforcement of the DIFC judgment were commenced. So the default judgment was dated the 13th of October 2016. At that point, Mr. Tamimi and his witnesses were in the process of giving evidence in the Royal Courts in Jersey. On the 19th of December, it's not disputed, the default judgment was sent by email to Mizar Chular. Her evidence is that she overlooked that. On the 15th of February, the judgment of the Royal Court of Jersey was circulated to the parties in draft. And on the 23rd of February 2017, it was formally handed down. Now, on the 27th of February 2017, the company's lawyers discovered for the first time about the judgment in default of this court. And that was because they were served with the commercial court proceedings in London, the only purpose of which was to enforce that judgment. There was then inter partes correspondence between the claimant's lawyers and the company's lawyers. And there was an agreement that the commercial court proceedings in London, the enforcement proceedings, would be stayed pending the outcome of this application, so long as it was made by the 20th of April 2017. And to bring us to the end of the chronology, this application was made on the 19th of April 2017. So within that time that the parties had agreed.
Do we have a copy of that agreement? Or is
Yes, and I propose to take you on to it later when I'm dealing with the other good reason for setting aside the judgment. If I may.
You didn't file it yet?
Sorry?
Have you filed that agreement?
Yes, it's in the evidence. It's in the evidence. I'll take you on to it in due course. Absolutely. And as I'm sure Your Honour has already intuited, that's the reason I say promptness is just not an issue. Because the claimant's London lawyers said, well, we'll stay these proceedings if you make your application promptly. And that's by the 20th of April, which we did. Fine. My learned friend can address you on that. I'll take you to the correspondence, Your Honour, and you can form your own view. The only other material thing in the chronology which came a week or so before the application to set aside was at the Jersey costs judgment, which Your Honour may have seen. It's a short judgment, and you've also been provided with the transcript. That judgment held that the non-disclosure of the proceedings here on the loans was a material non-disclosure, and the penalty for that visited on the claimant was indemnity costs, which were substantial because they were the costs of the trial. I'll take you to that judgment in due course, because it's important when it comes to the question of whether these proceedings were brought to the company's attention. So, I've set out the rule already. I'll turn straight away to the first of the three good reasons I say there are for you to set aside this judgment. The first is what I call jurisdiction. Now, there's two ways of looking at this. I say this court does not have jurisdiction. save to enforce a contractual agreement between the parties as to jurisdiction. And every court has that jurisdiction. The parties in this case agreed that Jersey has jurisdiction. And I'll take you on straight away, if I may, to the loan agreements. And this is Mr. Al Tamimi's case. You'll have seen from Mr. Blakely's skeleton argument in the Jersey trial, and from what Ms. Craig has said in her witness statement, that my client's position is that the loan agreements are just shams. So the loans are behind tab 5, and I'd invite Your Honour to look at page 96.
Yes.
So this loan is a loan agreement which is dated the 9th of July 2014 between Mr. Al Tamimi and First Connect Limited. It is materially identical to the loan agreement in respect of Jorum, so I'm not going to take Your Honour to that, but you'll notice on the previous 2 pages. And the relevant clause is clause 7. Before we go there, if you turn over the page, Your Honour, you'll see it says it's signed by the parties, and there's Rachel Wunsch's signature, a director for and on behalf of the company, and then it's witnessed by Edipali Maldonado, sorry if I pronounced that incorrectly, and then it's also signed by Mr. Al Tamimi, who describes himself as lender. Clause 7 says this: "This agreement shall be governed by the laws of the island of Jersey, and the lender hereby submits to the non-exclusive jurisdiction of the courts of the island of Jersey." Now that clause does 3 things, Your Honour. First is, it tells you what law applies, which is Jersey law. The second is that it says the courts of the island of Jersey have non-exclusive jurisdiction. And the third thing that it does is it recites that the lender, Mr. Al Tamimi, hereby submits to the jurisdiction of the courts of Jersey. So that's signed writing by Mr. Al Tamimi, who I pause to note is a lawyer of some distinction, submitting to Jersey jurisdiction.
For non-exclusive jurisdiction.
Sorry?
It says for non-exclusive jurisdiction.
Yes, it does. That's one of the 3 things it says, Your Honour. Non-exclusive jurisdiction clauses say, normally, the courts of Jersey have non-exclusive jurisdiction. The phrase they don't contain normally is that a specific party, hereby submits to that jurisdiction. So if Your Honour goes on to find that that's just a bog standard non-exclusive jurisdiction clause, that would be wrong, because it says something more than that. It says he hereby submits to the jurisdiction, non-exclusive of Jersey, but a submission to a jurisdiction is a submission to a jurisdiction, and this one's signed and it's in writing by Mr. Al Tamimi. Nothing that I've said is without prejudice to the case that these loans are jammed. I say that point's unanswerable. The jurisdiction I'm asking you to exercise is to enforce the negative contractual obligation that he had not to commence proceedings elsewhere, and the positive right that my client has under the contract, my clients under the contract, to be sued only in Jersey. In case there's any doubt about that, if you turn to the very back 3 pages in that tab, you'll see, I hope, an instrument of forgiveness and release, which I'll call a waiver for shorthand. And if Your Honour looks across at the second page of that, which is on page 232, it says this: governing law and jurisdiction. This agreement and any disputes or claims arising out of or in connection with its subject matter are governed by and construed in accordance with the laws of Jersey. Applicable law clause 5. 2.2. The parties, and the parties are the claimant and Jorum, irrevocably agree that the courts of Jersey have exclusive jurisdiction to settle any dispute or claim that arises out of or in connection with this agreement. Now, just whilst we're there, let me deal very quickly with two other points. It's Mr. Al Tamimi's case that this agreement was conditional on a sale going ahead. It doesn't say that anywhere in this agreement. What it says is that B of the recitals, to facilitate the sale of shares in the borrower, the lender has agreed to forgive the loans and release the borrower from all of its obligations and liability to the lender in connection therewith. And if you look just above that at the recital A, Your Honour, it says that the loans, up to the date of this agreement, are just about £8,000 in total. And if you look down to clause 1.1, it says this: the lender, that's Mr. Al Tamimi, the claimant, hereby confirms that the loans are the only loans he has made to the borrower. So as at the 1st of February 2012, he's only made loans on his case of about £8,000. Now, why is that important? It's important because the claimant relies on lists of payments. If you look at page 86 in tab 5, stress, Your Honour, these are accounting documents. I'm not going to go through them in any great forensic detail. The point I want to make is a simple and short one. And it divides into two. If you go down to, on page 87, about 2/3 of the way down, you'll see the date, 18th of 12th, 2011. And you can draw a line under that, Ron.
Okay.
The date's the first column, the amounts are the second column. And if you look up at those amounts, all the way back to the beginning of the agreement, Mr. Al Tamimi has said that those weren't loans. He said that in his agreement of waiver and release. And that's right, whether or not he's correct that it was conditional on sale, because he's declared in an agreement that those weren't loans. And that destroys his case in respect of Jorum, because all of these sums, whether they're before or after the line, were advanced on the same basis. And if the ones before the line weren't loans, then the ones after can't be. Not unless he wishes to introduce new inconsistencies into his case. There's authority for the proposition I'm advancing in respect of your jurisdiction to enforce these contractual obligations, Your Honour. And it's the case of USC, which is in my authorities bundle. I was helpfully informed that that's been provided to you. The case is the case of UST Kamengorsk, which is behind tab 4 of the authorities bundle.
Yeah, go ahead and make a reference.
Leonard French just helpfully indicated that he doesn't dispute that if it is an exclusive jurisdiction agreement, then this applies and this court doesn't have jurisdiction. Of course, the point I'm making is slightly different. I'm saying Mr. Al Tamimi is submitted to Jersey jurisdiction, and he can't go back on that because he's done that in a contract between parties. So the paragraphs I'd like Your Honour to read are 21 and 26 of that judgment, which encapsulate the proposition I'm advancing. Shall I take you on through them myself?
Yeah, go ahead.
Yeah. So 21 says this, after it, and this is the judgment of Lord Mans, and this is after dismissing an interpretation or a submission put forward by Lord Goldsmith Hughes. In each case, the negative aspect of an arbitration agreement is a feature shared with an exclusive choice of court clause. In each case, the negative aspect is as fundamental as the positive. There is no reason why a party to either should be free to engage the other party in a different forum merely because neither party wishes to bring proceedings in the agreed forum. Then it goes on to say, in 26, Lord Hobhouse also encapsulated the principle in Turner and Robert, which is the decision of House of Lords, 2002, when he said this: under English law, a person has no right not to be sued in a particular forum, domestic or foreign, unless there's some specific factor which gives him that right. A contractual arbitration or exclusive jurisdiction clause will provide such a ground for seeking to invoke the right to enforce the clause. And this is the key sentence. The applicant does not have to show that the contractual forum is more appropriate than any other. The party's contractual agreement does that for him. So, just to locate this submission in the jurisprudence of private international law, I'm not making a forum non conveniens argument, although I could, but my case isn't weak enough that I have to. I'm saying your jurisdiction is to enforce his submission to Jersey jurisdiction, and that's what this court must do. It's a non-competent forum submission. This is not the forum. He submitted to another one. In respect of the Jorum loans, that's absolutely certain, because you'll have seen in the instrument of waiver and forgiveness, the clause is an exclusive jurisdiction clause, and there's no doubt about that. But I say the clause in the loans on which the claimant relies is stronger for me, because it involves an express submission to the jurisdiction. So the next point is the abuse point. I say, and you'll have seen, Your Honour, in my skeleton argument, that proceeding here was an abusive process, plain and simple. I say that this point is as unanswerable as the jurisdiction point. Now, I want to clear up the factual point right away. My learned friend says in his skeleton argument that there's no identity of parties. That is, that the defendants here were not defendants in Jersey. That's just wrong. If you look at tab 13, page 600, page 600, line tab 13. Whilst Your Honour is finding it, I wish to make abundantly clear that when I criticise the case my learned friend is advancing, none of it is intended to be criticism of him. When I read his skeleton argument, it seemed to me that either he hadn't been prepared with, he hadn't been given proper instructions in respect of some matters, or he hadn't been given the right documents. You'll see there, this is the judgment on costs, which I mentioned earlier, where it was held that Rachel Wunsch knew that the claim issued here wasn't sent to Mazal Charma, the director of the defendants, and for that reason it was a material non-disclosure, and indemnity costs were visited on Mr. Al Tamimi. And you'll see there at the top, quite plainly, the parties: Al Tamimi, plaintiff, Al-Charmer, defendant, first grade, first party cited, Jorum, second party cited. They're parties. And that's not surprising. If one goes back to the pleadings in the Jersey claim, Your Honour, Jorum and first grade are all over them. The pleadings are, these are Mr. Al Tamimi's pleadings, are at page 98 behind tab 5. So, I don't know whether it's the same on everyone's copies, but on my copy there's a dark square over the parties cited. But if one looks carefully, one can see the title of the case is exactly the same as it was on the document I just showed you. First grade and Jorum are parties cited. You'll then see on the next page there's a description of the parties cited, and it says why they've been cited, so that effectively so they'd be bound by the result. And then, I won't take you to them now, but Jorum and first grade are the subject of paragraphs 32 through to 56 of the pleadings. So to say they weren't parties is flatly wrong, Your Honour.
Just from my understanding, this amended order of justice came. Why it was amended?
Sorry?
Why it was amended? Order of justice. The order itself was amended. Or?
Yeah, it's amended. And, I mean, I don't know whether the pleadings rules in Jersey are the same as in the UK. They appear to be. So what you can see is there'll have been an order of justice.
Yes.
An order of justice, of course, means statement of case in Jersey, confusingly. And the underlining throughout the pleading shows you the bits that have been added.
But the final judgment, including the both corporate name of the final judgment.
Yeah, the judgment makes factual findings.
That wasn't a question.
Well, I'm answering a question.
My question is the
Your Honour,
final judgment.
I know. If my learned friend wishes to address you, you can stand up and do so.
Yeah, of course. You can take a note.
The judgment itself
Yes.
is in here. It's at page 35.
Yes.
And you'll see the title to that, which just has plaintiff and defendant, and doesn't have the parties cited. That's an error. I'm sorry, is there any evidence
Yeah.
on which that is based? That's an extraordinary statement.
Please take your note. Take your note.
Oh, well, I'm sorry.
Don't worry. Yeah, go ahead.
Well, with respect to my learned friend's outrage, I don't think I need evidence in respect of that. So I'll say why.
Do we have like an original or authorized copy of the final judgment?
This is the final judgment.
Is it like a? Do you have like a stamp of like a?
Sorry?
Original copy of the final judgment?
I don't have an original, no.
You don't have.
But this is the approved judgment, and you know I have to live with the fact that those parties aren't there.
Right.
But they're there in the pleadings, and as you'll have seen, they're there in the subsequent order in respect of costs. They ought to have been here because they are parties cited, and that's because they are bound by the result. But anyway, I'll come on to address the factual findings made in respect to the companies.
All right.
It's not something on which I would need evidence.
All right.
So, they were parties. To say they weren't is wrong. Moving to the authorities, I'd like to take you on to the case of Henderson, if I may.
Yes.
Paragraph 2. Sorry, it's behind tab 2 of my authorities bundle. And if your Honour turns to page 319, using the top right page numbers, I'll read out the relevant proposition. Where a given matter becomes the subject of litigation in and of adjudication by a court of competent jurisdiction, the court requires the parties to that litigation to bring forward their whole case, and will not, except under special circumstances, permit the same parties to open the same subject of litigation in respect of matter which might have been brought forward as part of the subject in contest, but which was not brought forward, only because they have, from negligence, inadvertence, or even accident, omitted part of their case. The plea of res judicata applies, except in special cases, not only to points upon which the court was actually required by the parties to form an opinion and pronounce a judgment, but to every point which properly belonged to the subject of the litigation and which the parties exercising reasonable diligence might have brought forward at the time. So, that is widely drafted. In this case, as I'll come on to show, Your Honour, not only were the loans in issue, factual findings were made about the loans. So this is not a case where, in the litigation that had been ongoing, the claimant didn't put in issue the loans. The claimant said in his pleadings he was financing companies and always had, and there's no dispute about that. But the basis for that financing was contested, therefore it was an issue between the parties and factual findings were made. This is not a case where he just didn't raise the case. It was raised, it was contested, and it was dealt with. Of course, the default judgment came first in time, which is the odd feature of this case. You know, you've got a full judgment after trial, which came after the default judgment here. Pausing there. Going back to the London proceedings. The London proceedings were a petition on a loan, the Jorum loan only. Now, as I've said, at the final hearing, Mr. Al Tamimi decided not to pursue his petition when his adjournment application failed. There was a disputed process about which he knew. Sorry, there was a dispute as to the debt. There was a genuine tribal issue as to the debt about which he knew. That's why it was held to be an abusive process and indemnity costs were ordered against him. The reason for that was that there was a genuine forthcoming trial in Jersey. And the point taken by the claimant is, well, the trial in Jersey was just about beneficial ownership in shares in companies. It wasn't about loans. Well, why then did he capitulate in London? Because the petition was only about a loan. The point is, as you'll see from the judgment, I'm sure Your Honour's read it already, but I'll take you to the key passages. These companies were incorporated for a sole purpose. They were incorporated for purchasing properties in London. And the loans, the financing of them, was part and parcel of the whole transaction. And pausing there, it's been advanced to the other side that the loyalty gift made to Mazar Charma could have just been any increase in equity in the properties, which would mean that Mr. Al Tamimi could still sue for the loans. Now, that is an argument which is simply not available to Mr. Al Tamimi on the facts, and I'll show you why. I've mentioned at the end of my skeleton argument that if this default judgment is allowed to stand, it will simply eviscerate the judgment of the Royal Court in Jersey. And that provides a strong comity reason, as I've set out in my skeleton argument, for the judgment to be set aside. The reason for that, you can see, if you turn to tab 13, page 657.
Yes.
Your Honour, this is a letter from the claimant's London lawyers, Mitchell Moss. And I'd invite Your Honour just to read the first 4 paragraphs.
Okay.
Okay? So, I'll explain it first, then I'll show you how the bailiffs is granted in the Royal Courts of Jersey. If these properties were... Sorry, if the shares in the companies that own the properties were supposed to be a gift from Ms. Archalmer, and that's the finding that the Jersey court made after 7 days of trial, and yet Mr. Al Tamimi could simply sue the companies as a creditor for the money he used for the apparent gift, then it would be like giving someone an empty box. And don't take it from me, take it from the bailiff. He explains it better than I can. And that is at page 629 in the same tab. It's the bottom paragraph on page 629, and it goes over to page 630. It's just that comment of the bailiff. He explains the nexus, if it weren't obvious. And as I say, it was obvious to Mr. Al Tamimi in the petition in London, between the loans and the beneficial ownership. Okay? It would be the gifting of an empty box. So, back to the authorities, Your Honour. As a matter of domestic law, the courts have a duty to minimise duplication, multiplicity of proceedings, inefficiency in proceedings. If you turn, Your Honour, to tab 6. First reference. So this is tab 6 in my authorities. I can just read it out, it's easier. So, the first section I want to read out is from page 19, and it's about halfway down the first paragraph, a third of the way down. The Court of Appeal says that as a general rule of public policy, a claimant has to bring forward their entire case in a single action. And where they have a choice of remedies, elect which remedy to pursue. And then further down the page, and this is particularly apt in this case, this is the third paragraph halfway down from the in front, the avoidance of a multiplicity of proceedings is also enhanced by the court's powers to strike out proceedings in abusive process in circumstances in which the issues sought to be raised might have been dealt with in earlier proceedings. I stress the word might there because it's my case that they were raised, parties joined issue, and they were dealt with. It's obvious what a person has to do where they have another claim that's part of their case. And this is right whether or not you find that the defendants were parties to the Jersey litigation. Because it was all part and parcel of the same transactions. This is the bottom of page 83, and it's called Attempts. It's under the section Attempts to relitigate decided issues. And this is in the case of Aldi Stores, and it's Court of Appeal, and this is Lord Justice Thomas speaking. For the future, if a similar issue arises in complex commercial multi-party litigation, it must be referred to the court seized of the proceedings. It is plainly not in the interest of the parties, but also in the public interest and in the interest of the efficient use of court resources that this is done. There can be no excuse for failure to do so in the future. So what he should have done in the proceedings that have been ongoing since at least July 2015 is sue for loans against the companies. and not do it here. And there's a suggestion in Mr. Al Tamimi's witness statement that that would somehow have been inefficient. That is completely absurd. And the reason for that is, as I've already set out, all the company records, spreadsheet that I took you to earlier, resolutions, the loan agreements, Mr. Al Tamimi's accountant, Mr. Al Tamimi himself, Rachel Wunsch, were all before the court. In fact, it's absurd for him to say that it would be inefficient because the court did deal with the question of loans using no extra time. What's inefficient is duplicating proceedings here. It's also oppressive. How does that apply in private international law? Well, the answer to that is in Re Sena. It's in my authorities bundle, and I'll read out the relevant section here.
Just give me the page number.
Yes, of course. The page number is, so I'm in tab 3.
All right.
And I'm on page 493. And this is the judgment of Lord Diplock. To make available an issue of estoppel to a defendant to an action brought against him in an English court upon a cause of action to which the plaintiff alleges a particular set of facts give rise, the defendant must be able to show 1. The same set of facts has previously been relied upon as constituting a cause of action in proceedings brought by that plaintiff against that defendant in a foreign court of competent jurisdiction, and 2, that a final judgment has been given by that foreign court in those proceedings. Now, of course, I go back to the point that the default judgment came first in time. So this isn't a case where we've got a judgment and then there's a duplication of litigation trying to undo that judgment. It's a case where the ALDI criterion applies, set out by Lord Justice Thomas that I took your honour to earlier, which is that if there's something that should be raised in the proceedings, it's got to be raised in the proceedings. There's no excuse for not doing so. The only thing I want to point out about Re Sena and Lord Diplock's judgment is that he refers to a cause of action based on the same facts. So it's no good to run a different cause of action that's based on the same facts if there's identity of parties. It's not an excuse. So I want to take the honour to the authorities for what I hope is the final time. And this is Fentiman, which is his book on international commercial litigation. It's 2015 edition. It's behind tab 5. And the pages I would like your honour to look at are pages 441 and 442. I'll read the principles. In Racy and Hawilla, if I'm pronouncing that wrong, sorry, a claimant made related but legally distinct claims in both England and Lebanon. It was held that the Lebanese court was not an alternative available forum in which the claimant could proceed. So Spiliada principles did not apply. Your Honour will be familiar with those. They're forum non-convenience principles. But the Court of Appeal held that it was right to require the claimant to elect which action to pursue in the interests of justice and the efficient management of the case. The trial judge was right to conclude that it was oppressive to require the defendant to face 2 simultaneous actions and to require the claimant to elect in the exercise of his wide discretion in the interests of case management. The proceedings here, Your Honour, were no less than oppressive. As I've said, no further time, no further evidence would have been required in Jersey if the claimant had just pleaded his loan argument explicitly. The next section is page 443, and it's under 13.56. In English law, the focus is specifically upon the efficiency. Paragraph 2. Sorry. In English law, the focus is specifically upon the inefficiency of duplicate litigation. As between the same parties, efficiency suggests that the parties' dispute should be heard in one court. As between different parties, it suggests the claims against each defendant should be consolidated in omnibus proceedings. In such cases, the duplication of proceedings is inefficient in an obvious sense because it's wasteful in time and resources. But it is also inefficient insofar as parallel proceedings create a risk of irreconcilable judgments, which threatens additional costs and delay at the enforcement stage. Your Honour, we're in that situation right now. And the reason for that is, I say, that the decision of the Royal Court in Jersey is inconsistent with the default judgment. I'll come to the Jersey judgment in due course. It goes on to say in the next paragraph, parallel proceedings are not undesirable merely because they are inefficient. Where proceedings are substantially advanced, it is unjust to duplicate the action elsewhere. The point was made with particular clarity by Lord Gough in the Spiliada. Oppressive and unjust, that's what these proceedings were. Just to tell you where I am in terms of time, Your Honour, I'm now on the third, I say, excellent reason for setting aside the judgment. This I can deal with relatively shortly, and then my submissions on real prospects of success and the other matters are much, much shorter than these key points. So service. Claim was served technically correctly in Jersey. There's no dispute about that. I'd like Your Honour to go back to tab 13. And the paragraph that I'd like Your Honour to look at is on the second page of the judgment, page 601. It's the very final, well, it's just that paragraph, the first paragraph. Yeah. 600.
Thank you. So I should look to paragraph 2 or paragraph 3?
If you just read paragraph 2 from the top of page 601, where it starts, I think the non-disclosure is particular material, down to the end of paragraph 2.
All right.
Okay. We've got that email to which he's referring in the bundle, and I'll take Your Honour to it in a short while. First, I may wish to look at the exchange between counsel for Mr. Al Tamimi in the Jersey proceedings in this decision and the bailiff. Page 633. This is the transcript of that costs hearing before the judgment was given.
Yes.
And I'm going to start halfway down where Advocate Gardner, that's Robert Gardner of Bedell Christian, the claimant's lawyers. The fact that he's pursuing the debt claim against his own company is of no secret to anybody. So pausing there, it's not his company. He's no interest in the company. It's a matter of fact found by the Jersey court that Mazal Sharma is the sole absolute shareholder and has been from the start of time. He's not a director. He didn't have authority under the power of attorney. So that's wrong from Robert Gardner there to start with. The bailiff then says, it is what? And Advocate Gardner says, it's not a secret because, and he's interrupted, and the bailiff says, well, apparently it was. I entirely agree with what the bailiff is saying there. I adopt the word secret. These proceedings were secret, and I'll show you how that happened, Your Honour, by reference to Rachel Wunsch's evidence. So she's put in a statement. Don't know why it came so late in these proceedings, and she's exhibited various documents. I'm going to be looking at tab 15A, Your Honour. I hope that's made its way into your bundle.
Tab 15?
15A.
Okay.
So if you look at paragraph 8 of her statement, she says this: after I found out about my removal as director, when it was no longer appropriate for me to be dealing with STM on the company's behalf, I stopped replying to emails from STM and told STM not to contact me. Your Honour, that's untrue. It's just untrue. She found out, and it's common ground, it's her evidence that she found out she'd been removed as a director on the 1st of May 2015. Power of attorney was revoked over a year before that, so Mr. Tamimi wasn't in a position to give her instructions anyway in relation to the companies. But if you look at the emails she's exhibited, all of them are after the date on which she said she knew she'd been removed as director. That statement's false on her own evidence. So if you look at, in particular, page 682A. 682A, and then as is often the case with emails, the emails go backwards. So if you start on page 682A7, you should see halfway down an email from Kevin Shales.
Okay.
Do you have that, Your Honour? Yeah. So that's Kevin Shales to Rachel, who's Miss Rachel Wunsch of Tamimi Investment. She's the CEO, she's Mr. Al Tamimi's agent. The Royal Court found that Royal Court said that her evidence was that she just acted on his instructions. She in practice just always followed his instructions. Okay? This is 9th of June 2015. So it's after she knew she'd been removed as director. Dear Rachel, hope my email finds you well. I need to bring to the director's attention, which of course isn't her, that the attached documents were received at the registered office of Jorum Limited. As you can see, Mr. Al Tamimi has requested via the High Court of Justice that Jorum Limited be wound up. As explained in these documents, the company is insolvent and unable to pay its debts. Goes on. And then if you look at the page 6, so going back, from Rachel Wunsch, dear Kevin, please can you advise who you have contacted re this matter in your role as the registered agent with kind regards Rachel Wunsch. And of course by that time, Ms. Archarman knew about the winding up proceedings in London and had instructed me to go and appear, which I did throughout 2015 and 2016. So, moving forwards through the documents, page 682A9, Kevin Shales, December the 18th, 2015. This is after, on Rachel's evidence, she was aghast and shocked that she wasn't a director, and she told STM to stop emailing her. Dear Rachel, hope you're well. Further to my email below, dated the 7th of December, please can you provide me with an update on when the outstanding STM and Walker's invoices, as to when they will be settled in full. So there's the company's agent asking Rachel for payment for the companies. And finally, and most importantly for your purposes, Your Honour, are the documents on page 682A20 and the next few pages. 682A20 is an email from Wendy Boyle a year later, on August the 10th, 2016, to Rachel Wunsch. Hi Rachel, please find attached letters with claim forms for the above companies, and that, Your Honour, is this claim, DIFC claim. Should you require the original, please confirm. Kind regards, Wendy Boyle. And that's the email on which the bailiff based his conclusion that Rachel Wunsch knew that the documents hadn't been forwarded to Ms. AlFadhli, who was the director. But it also shows you that what Rachel Wunsch is saying in her statement is just untrue. And you see on the next few pages, there are the claim forms. It's worth turning over the page to page 22, Your Honour. This is Bedell Christen's letter to Jorum with the claim form. And obviously there's an identical one for first grade. So just to underscore the point, Bedell Christen, lawyers for the claimant, serving the claim on STM, Jorum, and its registered office. STM then sent the documents to the claimant's agent, Rachel Wunsch, who knows she's not a director. It's just an echo chamber, Your Honour. And that's why my client didn't know anything about these proceedings. Pausing there would have been the easiest thing in the world for an email simply to be sent to the lawyers who were instructed throughout that time for Ms. AlFadhli, namely Maguire Woods of London. Just to step back from that, Your Honour, what on earth is Rachel Wunsch doing there? This is totally illegitimate activity. Her case is that she and other directors acted on Mr. Al Tamimi's instructions at all times in respect to these companies. His power, it's a matter of fact, derived from the power of attorney given to him by Ms. AlFadhli, the director of the companies. He knew, and she knew, that that power of attorney had been revoked in May 2014. There was no basis on which Mr. Al Tamimi could give instructions in relation to the companies to Rachel Wunsch. And that's irrespective of whether or not she knew she was a director. Look who was paying the company's agents, Your Honour. So those are all good reasons in respect of which this default judgment ought to be set aside. I say that the first two, Your Honour, are also fatal to the claim hearing of the DIFC. That's jurisdictional and abuse of the process. It's a duplication of proceedings. It's oppressive. What he should have done is raise the loans by way of specific pleading in the substantially advanced Jersey proceedings, to borrow Lord Diplock's phrase. Those 2 points are fatal to Mr. Al Tamimi's claim, as well as being good reasons for you to set aside the default judgment. Real prospect I can deal with very quickly. I'll start with the London proceedings because they came first in time. It was found as a matter of fact in the Royal Court of Jersey that the treatment of these companies and their financing, their shareholding was identical. So Jorum and first grade. Financial treatment was identical. I don't think that's in dispute. The test that was being applied by Registrar Derrett, sitting in the Companies Court, Chancery Division, High Court of Justice in London, was whether or not there was a genuinely triable issue as to the loans. It was found that there was a genuinely triable issue. Mr. Al Tamimi knew that. That's why it was an abusive process. The test that's applied for a genuinely triable issue is identical to the test that you're applying today, Your Honour, which is there an issue that's been raised that's genuine and substantial? Genuine means one that has a real prospect of success. So if you decide there's no real prospect of success, that will be inconsistent with what Ms. Registrar Derrick found in London. I'm not trying to tie your hands, I'm just giving you the information. The second point, and this is the more, this is a complete defence to the claim here, I say, is the point I make in my skeleton argument. And I don't like to go to the skeleton in oral submissions, but I'll do so just because it's a quick way of dealing with it. Paragraph 19 of my skeleton sets it out. I've gone over some of this ground already, Your Honour, when I've been talking about service, so I'll just invite Your Honour to read that paragraph.
Yes.
She acted on his instructions. He had no power to give them. She knew that. So then the only thing that would remain then of the case is oral loans. But in respect of that, so the way the case is pleaded in the claim form here is that there were oral alternatively written loans, and the loans of the 9th of July 2014 are supposed to just formalise the position that everyone understood. But one of the points that was taken in front of Ms. Registrar Derrick in the Chancery Division was this. Well, I'll take Your Honour to it. Look at the skeleton argument for the proceedings in the winding up petition. I think it's about tab 5. Give me a moment, I will find it. Yeah. So, page 200. Your Honour, this is my skeleton for the hearing in May 2016, which was a month or so before these proceedings were issued. And invite Your Honour to read page 7. Sorry, not page 7. Well, it's on page 200, paragraph 7 and 8. So the loans are extremely dubious. If you haven't read it, I'd invite you to read Mr. Blakely's skeleton argument, the final section of that entitled The Loan Farce, which was prepared for the Royal Court's Jersey proceedings. We don't need to go to that now. What I would like to take Your Honour to is comment of the bailiff in the costs hearing in Jersey, which is back in tab 13 at page 640. The point that I'm making here is that if the claimant is driven back to rely on his oral loans, he's got no chance. Because Ms. Wunsch agreed to them on his case, but on her evidence she didn't. She just said there was an understanding. And if you look at page 640, the bailiff makes a comment about 2/3 of the...
640 or 14?
640, sorry.
Right.
This is his notes of the cross-examination of Ms. Wunsch.
All right.
Okay, so Mr. Al Tamimi is on both sides of the transactions, and Ms. Wunsch didn't agree alone. She just did what he said. So The final point is in relation to real prospect of success still, and it's the third reason there's a real prospect of success. I'm in the unique position today of being able to say that I know what the answer will be if the claim on the loans is tried, if it's specifically pleaded. And the reason I can do that is because it has been tried and factual findings have been made on the loans. And I'll take Your Honour through the key paragraphs of the judgment. My learned friend refers to one. It's in tab 5. It starts on page 35. And if Your Honour wants to take a note of the paragraphs, I can just leave Your Honour to read them. It's 15, 30 to 32,
Yes.
44, 66 to 72, and 83 to 84.
Okay.
Okay, and I'll leave Your Honour to read those now if I may.
I can go through later on, so
Sorry?
I will go through all of those paragraphs later on if you can. Just let me know what's your point.
Yes, okay. So the point I'm making is that there's much play made, and this is why
Reference to those companies. This is what you want to say.
yes, exactly. The point I'm making can be summarised very shortly. There's much play made by the claimants, and this is what caused me to think that perhaps my learned friend hadn't sought full instructions when he written his skeleton argument. There's much play made in that skeleton argument about company records showing that these were loans from Mr. Al Tamimi. Well, no. Those company records were before the court in the Royal Court of Jersey. And what the Royal Court of Jersey found after cross-examination of Mr. Al Tamimi and his accountant and other people, you'll see when you go through those paragraphs, Your Honour, that it refers to the accountant's evidence on, quote, Rusin current account, unquote, being incredible. It disbelieves Mr. Al Tamimi's case on the loans. And the finding is that there's no reason to strike down the company records that show that the loans came from Azar Charma. So that's why I'm in the unique position of being able to say there's not only a real prospect of success, but I've got a crystal ball that can tell you what finding will be made on the loans. So I've seen it happen. I can read the judgment. So if Your Honour reads those paragraphs in Your Honour's own time, I'd be very grateful.
Sure.
I'll deal very quickly now, if I may, with the question of promptness. As we've seen, there was service of the DIFC proceedings on agents in Jersey. That was the 3rd of August 2016. That was sent back to Rachel Wunsch. Although she'd known for over a year, she wasn't a director. It was not forwarded to Rusin Al Charma. And if Your Honour looks at page 194, behind tab 5, this is a letter from Maguire Woods, my client's lawyers, and it's a letter to Mitchell Moores, the claimant's lawyers, dated the 21st of March 2017. I'd like Your Honour to look at paragraph 15. We've made inquiries of STM in relation to the letter sent by Al Tamimi and Co. They tell us they've checked their records and can establish that the email letters were received into a general inbox, but they've been unable to ascertain if these were forwarded on. Our client instructs us she did not receive them. You've already seen the finding of the bailiff in Jersey on this. He says he found Rachel Wunsch knew that those claim documents did not go to my client. So the relevant date is the date in December when the default judgment was sent to my client. She says she overlooked that, and Mr. Al Tamimi says in his witness statement he wants her put to strict proof of that. Well, there's been no application to cross-examine her. She says she didn't see it. I say you've got to take, in those circumstances, you've got to take her evidence at face value. Also, you can infer she didn't see it, Your Honour, from the simple fact that she didn't react. As you can tell from me being here, great expense to my client, she's every intention of contesting this. And I refer you back to the empty box point. If she doesn't contest it, proceedings she's been contesting in Jersey for over a year at great personal expense will have been wasted, because Mr. Al Tamimi will be able to take back with one hand what he gave with the other. So the first discovery of the judgment in default was in February 2017, when the commercial court proceedings drafted by my learned friend were served on my client. And I'm going to go back to the point that my learned friend took issue with at the beginning, in case I have been inaccurate, and I hope I haven't, and if I have been, I'll correct myself. If you turn to tab 5, page 27, please. Tab 5, page 27. In fact, I think I may have got the page reference wrong. Sorry, I have got the page reference wrong. Can I just have a moment, Your Honour, to find the page reference? Forgive me, yes, it's 207. I beg your pardon. So this is a letter from Mitchell Moores to Ms. Laurie Craig of Maguire Woods, representing the defendants.
207.
Yeah, 207 is the relevant paragraph. Paragraph 27.
Yes.
And if Your Honour would read that, I'd be grateful. So the only point I was making about that is that the agreement, which is then embodied over the next 3 pages, staying the commercial court proceedings, is described in that paragraph in the following terms: our client would be willing to consent to a stay of these proceedings on the terms set out in the attached consent order to allow your clients promptly to bring an application seeking to set aside the DIFC judgment. I think the point my learned friend is making is that, or will make, is that that was without prejudice to his ability to argue that this application was not made promptly.
Yeah, so our client would be willing to.
Yeah, and then you'll see over the page.
But he didn't agree to.
He did. You'll see over the page. Yeah. So, page 211.
Yes.
There's a schedule to the agreement, and this was embodied in a final order, which I don't have, but it's in the same terms I'm instructed. 1. The defendants undertake to make an application to set aside the default judgment issued by the Dubai International Financial Centre, which doesn't describe this court correctly, but that's by the by, on the 13th of October by the 20th of April 2017, which my client did. In those circumstances, if my learned friend wants to argue that this application was not made promptly, I've no problem with that.
Is that document signed or not signed?
Yeah, it was signed and agreed. That document's not signed, but it was signed and agreed, and I don't think there's any dispute with this.
I'm looking to 210. Is there a signature there?
Well, I don't know if my learned friend can help me, but it's common ground that the commercial court proceedings were stayed on these terms.
Yes, they were stayed on those terms.
Yeah.
The commercial court proceedings were stayed on those terms.
Yeah.
There's no agreement that what has been done constitutes provenance. fine. But I'll make my submissions.
Yeah, thank you, Tom.
All right.
Yeah, I'm grateful to my learned friend for clarifying. Yes, sorry, that what you should have, Your Honour, which you don't have, is the stamped,
Yes.
signed version. But what happens is the parties, it may be the case here as well, the parties will sign a consent order and send it in, and then the court will produce its own version, which doesn't necessarily bear the parties' signatures. But those were the terms on which the commercial court proceedings were stayed. As I say, if my learned friend wants to make the argument that this application wasn't made promptly, of course he can. In respect of that, I would then have to refer you to Laurie Craig's witness statement, which deals with promptness. I can find it. Yeah. So it's tab 12, Your Honour. And if you would just read paragraphs 11 and 12, that deals with the material period of time between learning of this default judgment and making the application, which I say is a short period of time.
Okay.
Okay. That deals with promptness. The final point goes to a comment in my learned friend Scout's argument, which I don't understand, which says it's the final sentence. It says in part of the claim is to proceed. I think it's typo. It just means if part of the claim is to proceed. It should be on terms that the defendants first indemnify the claimant for the cost of the English proceedings. Well, with respect to my learned friend, I don't understand that at all. The English proceedings have been stayed in the commercial court by agreement of the parties. The only reason those proceedings were commenced was because my client didn't know about the DIC proceedings when they were issued, because they weren't sent to her. She then overlooked the email with the default judgment on the 19th of December, evidence which you have to accept in the circumstances. Mr. Al Tamimi is the author of his own misfortune that he has issued those commercial court proceedings. There can be no question of my client indemnifying him for those. In any event, you definitely don't have jurisdiction to make an order in respect of those proceedings. The way that that's done is by making an application to the commercial court for security for costs or such like. So I just don't understand that at all. Your Honour, unless I can assist Your Honour further.
Thank you very much.
Thank you very much.
Are you willing to respond now, or you want to take a break for the first 5 minutes? Up to you.
I'll respond now if Your Honour's happy to hear me.
Good.
Your Honour has indicated that you've had a chance to look at the skeleton arguments from both sides, and one thing Your Honour might have picked up on is that there is something of a mismatch between the written submissions. So my submissions in particular don't address the question of abuse of process, don't address the question of issue of stop, res judicata issues, the impact on subsequent proceedings of the Jersey judgments. Do address res judicata? Then, well, I don't address it. I deal with it as a side issue. I don't address it fully. I mention the point. What I say, thank you, is that if it were to be said that these were binding, well, then my clients weren't parties to those proceedings. It's correct that they were parties to the proceedings, but for a very limited purpose, and we'll come back to that. I don't deal with those points fully in any way. Don't deal with abuse of process. Why not? Because it was never part of the application. And so the first question is, what should be the scope of this application? evidence before we run out today. Can I just show you, Your Honour, what the application actually is today? So if you turn up tab 1, bundle 1, page 1, you see the application notice there. Tab 1, yes, it's the very first document, very first page and the very first document. So, Part A, default judgment should be set aside because, so these are the grounds set out, the defendants were not properly served with the proceedings, the sole director only became aware of the existence of these proceedings on 27 February, and the defendants have a full defence to the claim, as set out in the witness statement supporting this application. So it's very firmly grounded in we have a real prospect of success. And so when my learned friend started, he said, well, actually, there are 3 good reasons beyond real prospect of success, which goes in the other box of the rule. And then if we go forward to the witness statement that's attached, that's behind tab 4, and we go forward, please, to page 29, we see there grounds to set aside the default judgment. The defendants rely on a number of grounds. First, so on, so on, so on. So it firstly deals with not proper service and then says, paragraph 60, if the court considers that there has been good service, there's clearly a wealth of evidence that the defendants are not indebted to the claimant. So it's all directed at real prospects of success. So Your Honour will have seen that...
and I've asked this in the beginning of my hearing.
Well, quite.
You've answered that, thank you.
But what you've heard, what Your Honour heard, was different to actually what the application is. So all of these grounds that are being advanced are quite different. So then what happens is we get response evidence, so reply evidence aimed, directed at these grounds. Now, it's right, and I'll just flag this while we're in it, that at paragraph, on page 30, where I've just shown Your Honour, paragraph 60.5, it says, quite apart from the matter set out above, it is unclear why the DIFC court has jurisdiction, and so on and so forth. And then 60.6 does raise, in relation to the first defendant but not the second defendant, one of the jurisdiction agreements that Your Honour was taking to. So it's right that there are some smatterings, but they're all advanced to the question, does the defendant have a defence? To which obviously jurisdiction is not a defence. None of it suggests that the Jersey judgment creates some sort of issue estoppel. None of it suggests that there's another ground to set aside judgment because there is an abusive process. All right? Now, it's right. We then provide evidence in response to this, and then my learned friend submits some further evidence from Miss Craig. And it's right that, and I'll show you that, Your Honour, that, if I may. That's unfortunately, I'm afraid, in bundle 3. I'm in tab 12, so I don't need to show you very much of it, just to clear up what the nature is. Tab 12, bundle 3, page 578. So this is the second witness statement of Miss Craig, who is effectively taking the role as the solicitor in this case, albeit from my learned friend's cost schedule, it appears that my learned friend has drafted these, or at least had a very large input into these.
So can I just clarify that? Ms. Craig's not a lawyer in this jurisdiction. She drafted the witness statements. The reason they're not in the cost schedule is that her costs aren't sold.
Yes. No, but the point being that my learned friend has spent a week on documents, so 48 hours or something. So it looks like he's had significant input. That may be wrong. I don't dispute that. Right. Fine. So then what we have is, if we go to page 579, paragraph 17, we see, for the reasons set out in the witness statement supporting the defendant's application, the defendants have a real prospect of successfully defending the claim, and in light of the fact that this court does not have jurisdiction to hear the claim, and the ineffective service of the claim form, there are 2 other good reasons the default judgment should be set aside. So what this statement does is it seeks to add to the grounds. So it says, we have real prospects of success, that's the basis on which the application was made, that's the test, but there are 2 other grounds. and we'd like to insert them now. This court doesn't have jurisdiction, and the claim form, service of the claim form, was ineffective. So there's clearly a question as to whether or not the court should allow the application to be expanded to incorporate those grounds. And in relation to that, Your Honour may be aware, Ms. Craig put in a witness statement specifically to deal with the allegations made against her that she had somehow hidden this, that she was concealing it deliberately. And so there were personal allegations, sorry, not Ms. Craig, sorry, Ms. Wunsch, but personal allegations made against her. So she put in a witness statement. Response came back from Ms. Craig's third statement, well, you shouldn't be allowed to put in that material. So the defendant's taking the position that they can expand their application in this, but we can't answer it. And then what happens is we've got these three reasons, the way that the claim is being put now, which emerge in my learned friend's skeleton argument. And so the first is that there's no jurisdiction. So, fine. If Your Honour's happy to allow the application to expand in the way that we have in Ms. Craig's second statement, well then my learned friend's submissions on jurisdiction are broadly consistent with the case that's set out in that statement. Not in the application notice. It is relied on to some extent in the first statement. It's introduced in the second statement, and then my learned friend makes submissions. So I can see why he might say, well, okay, let's expand it to that effect. Res judicata and abuse of process, simply not identified in the application notice, not identified in the witness statements. They're not a defence anyway, so they can't be in the application notice. And then the third claim that's put forward is that this claim was kept, proceedings were kept secret from the defendant. I can deal with that, and it probably comes within the point about ineffective service. But the real question, it seems to me, is that the points about abuse of process, the points about res judicata issue estoppel are truly new. And I apologise for interrupting my learned friend when he said, for example, that the Jersey judgment made a mistake. There was an error in the Jersey judgment for not incorporating the defendants as the parties to that judgment. But the reason for that is that we've expressly checked this with our Jersey lawyers as to the effect of the defendants being made parties to the proceedings. And if there had been notice of these points, we could have given Your Honour some help on that. But the point about the Jersey proceedings, I'll come back to it in a moment, is the defendants were joined only for the purposes of getting interim relief against them. So an injunction to prevent things being changed. They weren't party to the substantive proceedings. Let me show you that. And the effect of that is that they're not bound, the defendants are not bound by the judgment. And if they're not bound by the judgment, they can't rely on the judgment. And that's the answer, or part of the answer, to the res judicata issues. My primary position, and on abuse, I'll deal with it insofar as I can, but my primary position is that when one comes to look at abuse, it's a complicated question, abuse of process, as a matter of both fact and of law. And those sorts of applications regularly run for days because it is a very granular textual analysis that is required of the relationships of the parties and what happened. And then one has to compare it to quite a lot of authority. My learned friends referred Your Honour to some passages from the White Book and so on, but it really is, there's quite a lot of that sort of material. So my primary position is that Your Honour ought simply just to confine this application to the application that was made, the grounds that were stated in the application.
Can I clarify one issue here?
Yes.
Al Tamimi lost the case in the Jersey procedure, so the Jersey judge found that Al Tamimi is his application over there, his claim was dismissed. Right?
Yes.
So did the Jersey judge issue any cost order?
Yes, there was a cost order. Yes.
And that cost order was
against both parties. But that's
the cost order was against the corporate, the company, or was against the...
No, it was in favour of the companies against Mr. Al Tamimi. So what happened was, he started the claim against his ex-wife, Ms. Shamlan.
Yes.
And that claim was to decide who owned the companies.
Yes, so that claim is dismissed.
That claim was dismissed, correct.
In that respect, when the judge dismissed that claim, did he order costs against
So then there was a costs hearing at the end of it, because as I've said, the defendants were introduced as parties to those proceedings for the purposes of an injunction.
I understand.
And I don't know what the cost order was.
Before that injunction, the cost...
Sorry, I can assist.
Yeah, just I want to clarify that.
Yeah, the costs order is written down in the final paragraph of the judgment that I took you to in respect of the costs hearing.
Yeah, I understand.
Yeah, so my learned friend's
So
absolutely
it
right.
wasn't like a separate cost or the...
It was a separate costs hearing. So the proceedings, the trial stopped, judge and the finders of fact went away, they produced their judgment, and then the parties couldn't agree on costs, so they came back and had the costs hearing, and there was an indemnity costs order against Mr. Al Tamimi.
Right.
And that's page 6, tab 5, page 600 and 601.
Yes, that's the judgment. I wasn't aware that there was a second order, but in any event, it records the order that's being made.
Yes.
And that's, but that underlies the point, because the Jersey court makes that judgment and includes the defendants as parties to that judgment. Why? Because they will have incurred costs in responding to the claim for interim relief. But they are not included in the main judgment on which my learned friend relies for findings, because they're not parties to that part of the action. And my learned friend says, oh, it's just an error. That's the first time anybody has ever said that. And it's completely inconsistent with what I'm being told from Mr. Al Tamimi's Jersey lawyers. But we can't get into that today. Why not? Because the first time we hear this is going to be raised is in the skeleton argument that's put forward on Monday. It's completely unclear. So my learned friend's been trying to exchange skeleton arguments with me since Sunday, because he, I say, misunderstood the rules and thought that was the time when it needed to be exchanged. And it sounds like he's had heavy input into these statements. So at some stage between these statements and that skeleton argument, the defendants must have realised, well, actually, we're not going to confine ourselves to the grounds which is in that statement. We're going to run some other points. Why didn't they then come to us and say these are the points? I'll deal with the points as best I can, if I may, because Your Honour may not want to make a decision on that immediately. So Your Honour, I'll start with jurisdiction, if I may.
Yes.
That's the first point my learned friend made. The first point he then makes, he relies on the loan agreements. Now these are the loan agreements which support my primary case in this claim. That is by those documents signed in July 2014,
Yes.
all of these payments which had gone before, it was agreed that they would be treated as loans repayable on demand. And all of the payments that come after, they will also be treated on that. And you Honour will have heard my learned friend's position on that. He says, well, those are sham documents, but by the way, I rely on them for these purposes as contracts. So he takes the primary position that those loan agreements contain jurisdiction clauses which are binding on the parties. That's what he says.
Right.
Now the problem on those loan agreements, my learned friend, is that they are expressly in terms non-exclusive. The parties submit to the non-exclusive jurisdiction of the Jersey courts. I can take Your Honour back to those if necessary, but I don't think it's necessary unless you'd like to read it again. And what that means is that the parties can go to Jersey if they choose to. It doesn't prevent them from proceeding elsewhere. And my learned friend emphasises two things, well, one thing in particular, and then took Your Honour to some authorities. I don't want to go back to those authorities. My learned friend emphasises the words, hereby submits. So what the jurisdiction agreement said was, the parties hereby submit.
No, the lender.
All right.
That's fine.
The lender, thank you, hereby submits to the exclusive jurisdiction of the Jersey courts. And he says, well, there's some magic in the words hereby submits. That submitting to the jurisdiction thereby creates, in effect, a contractual right not to be sued anywhere else. But a jurisdiction agreement always amounts to a submission to a jurisdiction. If I agree to have my disputes with my learned friend decided in this court, we are both taken to have submitted to the jurisdiction of this court. So the fact that we then say in our agreement, well, we thereby hereby submit, is neither here nor there. It just confirms the case. But it's a submission to the non-exclusive jurisdiction. It's difficult to understand how, in my learned friend's case, one could ever have a non-exclusive jurisdiction clause.
Now the question is, before the claimant filed the original claim, the default, when he gave the default judgment in 2016, right?
Yes.
Before that, did the claimant start proceeding in Jersey against the claimant, against the defendant? Or?
So only to the extent that they were brought into the Jersey proceedings for injunctive relief.
Yeah.
So there's that. There's also the winding up petition, which my learned friend relies on a lot. So there's that. Okay, but
you get my point clearly. I mean, what I'm trying to say here, I mean, if the argument is that it's non-exclusive jurisdiction for Jersey, but the claimant did already decide to interpret that clause by starting the proceeding in Jersey in some form of petition or another claim form, so that might give some perception the claimant is indeed understanding that he wants to, approach the Jersey judiciary.
I see. But it was different. It was a completely different claim. So because all it was doing was to hold the position while the issue was decided about who owned it.
Not
that's
making
the
any
first.
decision now.
Yes. No, I understand, but it's a different claim because it was a very limited claim in Jersey. I'll show it to you.
And those claims wasn't based on the loan agreement?
No, the claim against the defendant in Jersey could not on any view be said to be based on the loan agreement.
Okay, sorry.
So the position in Jersey, and I'll show it to you, was that there was a claim for an injunction, an interim relief against the defendants on the basis that there was an argument about who actually owned them, and therefore steps should not be taken in the meantime until that issue was resolved. There was no creditor claim advanced against the defendants in Jersey. And the other point is that, in a sense, it doesn't matter what happened next. The question, my learned friend says, well, the effect of this clause is to confer exclusive jurisdiction onto Jersey, or one way or another to prevent my clients from bringing a claim in any other jurisdiction. But and so one just has to look at the words. It doesn't matter what happens next. One looks at the words because that's how one understands the meaning of that agreement. And it says in terms non-exclusive. My learned friend took your honour to some cases, the Ust-Kamenogorsk case, and paragraph 21 and 26 of that. When your honour was reading it, no doubt your honour will have seen that was dealing with exclusive jurisdiction agreements. In fact, it's dealing with an arbitration agreement.
Yes.
And it says the negative promise in an arbitration agreement is not to sue someone anywhere else other than arbitration. It doesn't help you with the question of whether or not this particular agreement is exclusive or non-exclusive. But it seems to me a pretty bold submission to make to say that the effect of this is an exclusive jurisdiction agreement, when in fact it says non-exclusive. Sorry, my learned friend wants to say something. He's been making quite a lot of comments along the way, but if you'd like to interrupt, then I'll reply. No? Thank you. And it's worth pointing out that Miss Craig's evidence accepted that this was a non-exclusive jurisdiction agreement. So the position that was taken on behalf of the defendant in this case was that the agreement in this loan agreement was non-exclusive, was a non-exclusive jurisdiction agreement. That I'll give you one of the reference, paragraph 42, bundle 1, tab 4, page 21.
Right.
paragraph 42. So the next thing my learned friend does is he relies on a totally separate jurisdiction agreement, which he says governs the same dispute. Now, he took your honour to that document, which was a release document. Does your honour, would it help to go back to that?
I've seen it before, but just make a comment. Yeah.
So comment 1, that document only applies to the first defendant. Comment 2, it is dated 1st of February 2012. So it comes before the loan agreements.
Right.
So my learned friend can't get home on this either, because if the parties agree...
Can you just remind
Yes.
me, the date was, that release agreement, the date was written by hand or by
I don't think it's disputed. Can I check? It's at page 5231. Now the date's typed in.
typed in?
Yeah.
2012.
2012, so 1st of February 2012. So the point is, if I agree with my learned friend, our dispute should be subject to the jurisdiction, exclusive jurisdiction of Court A, and then we come back 2 years later and say, we agree that our disputes should be subject to the jurisdiction of Court B, and then Court A, the agreement about Court A is overridden, is amended by agreement. And you can't end up with 2 inconsistent agreements about where these disputes should go. And so the same point applies. If we've agreed that there should be exclusive jurisdiction to this court, and then agreed there should be non-exclusive jurisdiction to the same court, then the agreement is amended so far as it applies. Now, I have some observations about those releases anyway, but I'll come back to them later on if I may. But my first point is that the jurisdiction position that my learned friend puts forward is hopeless, even if he's entitled to raise it. I wasn't clear from my learned friend's submissions whether he is taking another point, which is that this court has no underlying jurisdiction at all under the judicial authority law. I don't know whether he takes that point. I had understood at the beginning of his oral submissions that he was going to say something along this line, but then he didn't develop that position. There are some comments to that effect in the evidence, but again, it doesn't seem to be a point that's being run here. The evidence which supports this court having jurisdiction is contained, I'll just give you another reference.
Article 5.
I'm sorry?
I'm going to the judicial law.
Oh, I wasn't going to take your honour to the judicial authority law, but the evidence which supports it. The evidence which supports it says, amongst other things, that the loan agreements were entered into...
A witness statement of Mr. Essam.
Yes, quite, and it's yes. So there's sufficient, and I don't think it's seriously been engaged with to say that doesn't apply. But the loan agreements were entered into in the DIFC. That's the first point. And the payments instructions were given from the DIFC. So these are agreements that entered into subparagraph B, or alternative transactions, part of or events partly related to partly rising in the DIFC.
Based on Al-Kharafi case.
Kharafi, yeah, yes, one of the many cases in which we've dealt with those sorts of issues. So that's the jurisdiction side of it, and then we have the abuse of process issue estoppel elements. Now, as I say, I will deal with these as best I can.
Just before leaving,
Yes.
Are you leaving the jurisdiction?
I was going to move on, yes.
Just when I saw those documents and submissions, just one of the ideas came to me, whether or not it might be an argument about opt-out from this jurisdiction to the DRC jurisdiction.
Yes, so that would have to be an exclusive opt-out. So this is my learned friend's point about it being exclusive, because if we just say, you may sue over there, then that doesn't stop me from suing here. Unless you say you may sue over there, you must sue over there. So yes, that's right. My learned friend's submission about all of that would amount to an opt-out from the DIFC. Okay.
So we can move on.
Abuse of process issue of estoppel. As I said, these are new points. I deal with them as well as I can. but always subject to my submission that Your Honour simply shouldn't engage with these. On res judicata, I'd just make two big points for me. The first we've been over to some extent. You have to be party to be bound. And I want to move forward because we're going to run out of time.
Just give me a reference.
If I give you Your Honour the reference. So, in fact, my learned friend took Your Honour to this, but it's the relevant parts are Bundle 1, Tab 5, page 99,
Yes.
which are the pleadings in Jersey, and then page 115, which sets out what the case actually was against the defendant. So it's injunctive relief. It's clear, so from those documents. Then the judgment itself doesn't name the defendants as parties to that judgment, and that's page 1535. To get around that, my learned friend says, well, it's a mistake. Well, all right, he says he doesn't need evidence for that. It's just obvious. It's not obvious.
And that, yeah.
And then the cost judgment does include them as parties, and we've been over that, and that's my learned friend made the point. Bundle 3, tab 13, page 600.
All right.
So the judgment on which my learned friend relies is only between the claimant and Ms. Al-Shamar, so it's only binding on them. And in fact, just to show them how the defendant's case is developed, again, the defendants in their evidence expressly said that the injunctions are not relevant to this application. So that's the claim for the claim in Jersey against the defendants was for injunctions, and the defendant's evidence says the injunctions are irrelevant for the purposes of this application. You want to find that in Ms. Craig's statement, second statement. The reference is Bundle 3, tab 12, page 582. And it's paragraph 28.4. And as I've said, for what it's worth, we've made inquiries of the Jersey lawyers who are clear that it's not binding on and therefore can't be relied on by the defendants. But I can't help you with that on the basis for that because of where we are. And actually, the way it was put, again, another reference to my reference, evidence, the same one, the way it was put is that the Jersey judgments have evidential weight. It wasn't suggested that they were anything more than that. What's being said now is the findings are binding. But then it was being said, no, they have evidential weight. So in other words, the court would be persuaded that those facts were correct by relying on them. The reference to that is at Bundle 3, tab 12, page 580.
Right.
That's paragraph 21. The second point on the Jersey judgments, res judicata, just dealing with it that way,
Yeah.
is that the DIFC judgment came before the Jersey judgment. So at the time the proceedings were being pursued, and at the time that the claim was decided on by default, there was no Jersey judgment.
But was there a procedure?
I beg pardon?
I mean, there were a procedure in Jersey court.
Yes, there were. Yes, but he takes 2 points as a result of that. Firstly, he says, well, you're bound by the findings in Jersey, and second, he says there was procedures in Jersey, so it's abusive. Those are the 2 points. So I'm splitting them out and just dealing with the question of whether it's binding first, and then I'll come on to the next question, the abusive question next. But at the time that the judgments were entered in this court, there were no findings
that
to
was
rely
in
on.
October, then the judgment came in November.
In February.
February, yes, sir.
Yeah. So that what the defendants are trying to do is rely on developments which occurred in the time when they failed to respond to these proceedings. So I say that couldn't on any view be a reason to set aside judgment in default. And then the third point is that one just has to understand the scope of the decision that was made in Jersey. And as I say, that decision was all about who owned those companies. It wasn't about...
So the merits of the dispute over there was the ownership of the company.
Yes, that was the aim. And there were findings. My learned friends directed Your Honour to the passages, and I just ask Your Honour to look through that and find whether those are essential parts of the decision that were made in Jersey. Because if they're not binding. As a matter of res judicata, it has to be it's rather like the UA law position. It's the same. It has to be an essential element of the decision. And ultimately, the decision is about ownership. And then secondly, if one actually looks at those passages and what they actually say about these loan agreements, they say very little. So they don't look at the kinds of points I'm going to take you on through in a moment, which just show that these are clearly loans. So take just one example of this. Loan agreements in July 2014. My learned friend says that's a document that is not binding for various reasons. It's a sham document, he says. After that loan agreement, Mr. Al Tamimi made about £1.3 million in payments to and on behalf of the defendants after the loan agreements. So the idea that those were gifts, which is my learned friend's case, just can't be right. That's just one example. I'll take you on through the chronology of that in a moment. But the main point is that that Jersey judgment was not intending to deal with these claims in any way completely, and as far as I can see, it doesn't make any final conclusions on the kinds of points that my learned friend makes about whether or not the loan agreements were binding. But you only can look at those passages of the judgment anyway, if we get there. Shall I say we don't? So then we move on to my learned friend's argument about abuse, and I say, well, the same two fundamental points arise about the abuse argument. Because abuse will not normally apply where a party brings one claim against one person and then brings a later claim against another person. It's not impossible, I accept that, but it is much less likely to be abusive if you are bringing a claim against a different person the second time around. It's far harder to establish abuse. And in the Jersey proceedings, the claimant did not bring at least substantive claims against the defendants in Jersey at all. They brought claims for interim relief, which my learned friend's own evidence accepts. Those injunctions were irrelevant to the claim being brought in this case. So it's not being said that there's some sort of similar claim was brought, or can't be said, some sort of similar claim was brought against the defendants in Jersey. So we're into the zone of someone saying, well, you brought a claim against the shareholder for the ownership, and you should at the same time have brought a claim against the companies for the loans. That, as I say, because it's saying that the second claim is against a different party, it's much harder to establish abuse. We don't have the full authorities on all of this. We do have in the bundle a case called Johnson and Gore Wood, which is still the leading case on this. And the points there are that it's partly in my learned friend's authority, which I took your honour to, which is an extract from the English White Book. I won't take you back to it, I'll just tell your honour for now and give you the reference. It's the Defendant's Authorities tab 6. And
Yes.
principles were summarised in a later case, and I'll just pick out some of them. A later action against a different party is much less likely to be an abuse. That's point one. Made that point. Just because a claim could have been raised does not mean it should be raised, or that later proceedings are an abuse. Point two. Depends on all the circumstances. And in fact, Johnson itself was a case where a person who controlled the company, he brought proceedings in the name of the company, and then he later brought proceedings on the same matters in his own name. It was said in the context that was not an abuse. So simply the nature of the relationships between the parties doesn't get you to abuse. And the final point is that the second set of proceedings will rarely be abusive unless there is unjust harassment or oppression. So we need to investigate all of that. My learned friend showed Your Honour's passage from Oldie Stores, which said, I won't paraphrase, I'm afraid, because my learned friend will interrupt me. Just simply, I will say this, that what he didn't do was take Your Honour over the page. So if Your Honour goes back to that, it's the same passage, Oldie Stores. There's a case called Akroiti, where Mr. Justice Knowles made the point that simply, even if Your Honour was happy that there was some failure to comply with the guidance in the Oldie Stores, Mr. Justice Knowles says failure to comply with that guidance isn't by itself abuse. So that's the sort of legal backdrop to it all. But there is plenty of authority about this, I can promise you. And these sorts of applications end up with many, many bundles, I'm afraid.
The only difference, the only difference in our case is we have different jurisdiction.
Yes.
I understand that where you are not, there's no need to bring all your action in one case, or you can divide those actions in different cases, or you don't need to bring the loan claim in the same case where you file against the social shareholder. But that within one particular jurisdiction, acceptable.
Yes.
But now we are dealing here in a different scenario where the claimant bring some action in one jurisdiction, then he decide to bring different sort of action in different jurisdiction.
Yes.
And this is the question need to be answered.
Well, quite. But so there is part of an answer in my evidence, but the point hasn't been raised. And so the reason why the first set of proceedings, as I understand it, and I'm assuming, this is not because I have any information about this, I assume the reason that the first set of proceedings was brought in Jersey is because that's where the companies were incorporated. And so they needed a decision of the Jersey courts to make sure that the effect was of the ownership of the company was followed through, and therefore that it would be finally decided as to which party owned that company. That presumably is the reason it was done in Jersey. The reason the loan claim was done here is because all of the events which led to it occurred here. All of the witnesses, we would say all the key witnesses at least, then about all the witnesses, would be here. Because the claimant lives here.
Right.
The events which led to the loan agreements occurred here. The individuals who signed those loan agreements live here. And the defendant is now, whose shareholder has now been found to be Ms. Al-Shamar. Ms. Al-Shamar lives in Dubai.
Now those events which is linked the claimant to the jurisdiction of the IFC are in dispute from the defendant.
Well, effectively, yes,
right?
Because what he's saying is that
it might worth to be weighted in a real course of hearing with listening from the witnesses to approve those events, which will make the link of jurisdiction between the claimant and the DIC. If you get my point.
Well, one wouldn't normally have a trial to decide on jurisdiction.
No, my real point is, when it's come to the jurisdiction and this kind of stuff, we have alleged events that, the claimants manage those and conduct this loan agreement from the DIC. So the claimant,
is it disputed that was the position?
Yeah, this is the position of the claimant. Now, the defendant, my understanding, is not in contents with this argument, and he always, in his skeleton argument and submission, dispute those things. So my point is whether or not, when I'm dealing with the application to set aside the default judgment, whether or not we need to give the defendants another round or another chance to argue about those defense, or to or give the claimant at least the opportunity to bring sort of evidence under oath to bring the jurisdiction of the IC. This is my
yes, I see. I don't understand that it's disputed that the loan agreement was signed with the DIC.
No, the loan agreement, the connection with the DIC.
And I'm not sure whether it's disputed that the claimants, at least for a period, the defendants, at least for a period, were being managed from the DIC, and it's beyond argument, it seems to me, that Mr. Al Tamimi operates and works in the DIC, and so it's very difficult to say that when he's giving instructions for payments.
We need to make attention. This is not like a jurisdiction where the person will bring a jurisdiction based on his residency in the IC court.
No, that's not what I'm saying.
We need to.
I'm saying no. So that wasn't my point. My point was that he works from the DIFC, from offices in the DIFC. So
doesn't still. This is not.
No, I didn't. Yes, but I'm not relying on that by itself. I'm saying so.
Agreement loan itself.
No, not just that. But when he makes the payments,
yes,
he gives the instructions from his office. He says.
Right.
So how is that's not?
He says.
Yes, quite. You're.
And that statement wasn't brought to the DIFC under oath. Instead, this is a statement of truth.
Yes, it is a witness statement.
Yes, I understand that.
But he's not. You wouldn't normally have somebody give evidence as a witness in court, be cross-examined for the purposes of a jurisdiction dispute. That's not normally what happens. Is my client would put out the reasons why he says the DIFC has underlying jurisdiction, and then the other side would say we dispute this or we don't dispute that. But at the moment we're not there because this is the nature of the application that's been made.
Because the defendants came to the DIFC court asking the DIFC court to set aside the default judgment so that he can go back again and argue about the jurisdiction or argue about the substantial matter in the proper hearing. And in the face of it, the DIFC court jurisdiction is not that much straightforward, clear, in terms of there is no opt-in clause, and the claimant is not a DIFC entity, or in terms of a corporate, it's a person who is signing those contracts. The only window for the claimant is to argue about his conduct the contract through the DIFC or from the DIFC jurisdiction. And this window, this argument itself, need to be brought to the DIFC court with more proper evidence.
Well, if my position is, if that was to be an argument that was going to be raised, it's an argument that needs to be raised by my learned friend. He doesn't rely on today, as far as I'm aware.
Can I just assist? And I hope to assist my learned friend and the court. I entirely agree with my learned friend that
I will give you an opportunity to reply if you don't mind. Just a little. I don't want to. Just want to clarify my point. Then you can reply to those.
Of course, it's just one sentence, Your Honour, which I think will help. I agree with my learned friend as to the correct approach to disputes about jurisdiction. I rely fundamentally on Your Honour's point, which is that he'd already submitted to Jersey jurisdiction by launching proceedings there. There's no dispute that he conducts his business from here. Some of the meetings, I should say, the minutes of the meetings that have very properly been put in by the claimant show that the company was having meetings in Jersey, but the later meetings relating to the loan agreements were, as my learned friend rightly sets out, DIFC.
Okay. So, this is sort of two questions here.
Right, and this is why. This is my approach, and all of those questions might need to be answered through a proper hearing, proper procedure.
Perhaps.
Not just on the spot of this application.
Well, quite. But my point is that if that is an application that my learned friend wanted to make, that if he wanted to incorporate that into his application, then he could have and should have done that. We're here today to deal with the application that was made.
Yeah, to set aside default judgment on the basis there is a proper,
a real prospect of defending.
Yeah. And defendant or arguing the jurisdiction, which is
well, jurisdiction is not a defence. but if you're honest concerned about jurisdiction, I can deal with that. My learned friend's just said, except that the subsequent meetings happened in the DIFC, and as I say, the loan agreement was signed in the DIFC, and I don't know whether my learned friend disagrees with that. But unless somebody disagrees with some of that, you don't need another hearing to decide the issue, because that is the position. Yes, it's what my client says, but unless somebody says something different, and that is what the court accepts, that's the way it works. And at the moment, nobody's saying anything different. Your Honour will be well aware of Article 5A(1) of the judicial authority law, and it's not just obviously having DIFC establishments.
Yeah, I understand that. For the signing and conduct the contract from the DIFC or part of it from the DIFC.
Yeah, but so that the facts supporting the conclusion that this court has jurisdiction simply aren't in dispute. There's no argument, ultimately, about whether or not this court has underlying jurisdiction. The argument comes when my learned friend relies on these other jurisdiction agreements that he says take it away from the DIFC court. That's where the argument is. Just very briefly, two more points, three more points if I can on abuse. Firstly, it can't be said that this is a claim that has been held back. I'll deal with the secrecy elements of the way in which the claims were served, but certainly the claim itself, it's been well known all along that the claimant claims to be a creditor, quite independently is claimed to be the owner of the companies. It's also right that the defendant, and including Ms. Al-Shamar, saw the loan agreements at the time and said nothing. So at the time, that's in 2014, Ms. Al-Shamar was sent copies of the loan agreements. I'll give Your Honour the reference to that. It is Bundle 2, Tab 9, page 325.
295?
325. 2, Tab 9, page 325. Yes. That's an email 27 July 2014, so shortly after they're signed. It's clear that from those documents that he's claiming to be a creditor. They obviously knew about the winding up proceedings in London. That's an enforcement process. So the result of that was you can't go through that enforcement process until you've established your right. And you can't establish your right in those proceedings. And the outcome of that was that my client had to go off and fight the claim in another jurisdiction, which is what it did. Now, my learned friend says that should have been in Jersey. I say, well, no, that's ultimately a forum non-argument, forum non-convenience argument, which my learned friend doesn't make. So we'll come back to that in a moment. And then the point, it was clear as well, in Jersey, that my client continued to claim to be a creditor of the companies. Wasn't advancing claims. And no one said at that point, well, if you want to make that claim, you've got to do it now. No one said, you've got to amend your claim, bring in the defendants into the substantive claim, and advance your claim under the loan agreements now. No one said that. So there's no arguable basis to say that somehow this was a case that was kept up my client's sleeve. It was all out in the open. And the second point on abuse, the second big point on abuse, my learned friend's arguments see all of this from the point of view of now. That is, what would happen if these proceedings were revived? And it comes back to this point that when these proceedings were commenced in the DIFC court, there was no concluded proceedings in Jersey. And proceedings in Jersey were less advanced at that stage, a year ago. So the argument, if my learned friend had made the argument then, if the defendants had responded to the claim, the argument would have been cast as a forum non-convenience argument, or a lis alibi pendens argument, or something like that. Ultimately, if one winds the clock back to the beginning of this case, the defendant's position couldn't have been this is an abuse, because there would have been no final proceedings in Jersey. It would have had to have been that this is not the convenient forum. And so we would have had, at that stage, a forum non-convenience argument. And that's the point about going to Jersey. Proceedings in Jersey would have been relied on by my learned friend to say, we've already got a process going on in Jersey, isn't it better to do it in Jersey? And so this court would have been asked to decide on spiliada grounds, on forum non-convenience grounds, to stay the proceedings here so that those proceedings could be heard in Jersey. So effectively, what's happened is because of the failure of the defendants to respond to the claim, you have in effect, a forum non-convenience argument being promoted to becoming an abuse argument. And so they're relying on their own failure to respond to the claim to make the argument better. My learned friend says, well, he's not going to make a forum non-convenience argument. Well, that seems to me is the end of it, because you can't can't take into account the effect of the delay, benefit that he accrues from the delay, as a reason to set it aside. And the third point, final point on abuse, is that the strength of the claim can be taken into account in the right circumstances in an abuse argument. If the court agrees with me that there's no arguable defence to this claim, then that is an issue which would be taken into account in deciding on a question of abuse. So it would be a heavy reason not to strike out a claim, even if it would be otherwise abusive. And again, we don't have full authorities on this, but there is support for that in the Defendant's Authorities, tab 6, page 84. So my learned friend's third big point when he started was that all of this was kept secret at the start of the proceedings. Absolutely, that is disputed, and I'll come back to the chronology of that if I may. But in my submission, it comes at the end, because it goes down to the question of discretion. If there are real prospects of success, should the court exercise its discretion to set aside the judgment? And that would be part of that calculation. And put it another way, if Your Honour accepts that there are no real prospects of success, Your Honour should not set aside the judgment on the basis of those sorts of allegations. So I'll leave that to the end if I may, and I'll just come on to the question of real prospects of success, which is what my skeleton argument is targeted at, and what I suggest should be really the reason, the issue in this application. The test is real prospect of success. The authorities show that the defendant has to show more than a merely arguable case, and the burden is on the defendant to show that. And when we look at these issues, it seems to me, we see why the defendants are so keen to raise all these other procedural points about abuse of process and res judicata. Because those are all points which would stop this court, if we were to open up the proceedings, those are all points which he says would stop this court looking at the merits of this claim at all. Because you're bound by this, or it's abusive for that reason. You can't open the merits. That's his primary position. This court just shouldn't be allowed to deal with this claim. Not on jurisdiction, not just on jurisdiction grounds, but also because, frankly, you're bound by what's come before. The starting point for all this, and remind Your Honour, is that there are these loan agreements, and Your Honour's been taken to them. I'll take back to them. But my learned friend's position on them is that they're not binding, and he puts it that they are sham agreements. That's what he says. And I'll come on to that, but I just highlight that that is an allegation of fraud. And the first point I said, thank you. The first point I say about that is my learned friend actually relies on the loan agreements for the purposes of jurisdiction. But I think that the first thing to do then briefly is just take it chronologically in terms of how these payments were made. I'll run through that quite quickly if I may. Because we can plainly see that some of these payments clearly were loans, at the beginning at least. And Your Honour will recall that initially the defendants had directors who came from Jersey. I call them the continental directors, but they didn't last that long, and they were ultimately replaced by Miss Bunch, you all heard about, Mr. Sharif, and then he was replaced by Mrs. Ban Al-Dada. And so the key issue, ultimately, as to whether these payments are loans or whether they're gifts, is going to be whether it was intended by both sides, that is the directors of the companies on the one hand, the claimant on the other, whether it was intended and agreed that they should be repaid. That's the question. So when we go through the documents, the underlying documents, we can see that clearly the intention was that they would be repaid. The starting point, if I may take Your Honour to it, is the director's resolutions that come at the beginning of the relationship. So that's Bundle 2, Tab 9. Page 315, this starts.
Page?
I'll start at 315, if I may. Sorry. 313. Thank you. So you've got a director's resolution from First Grade Properties, that's the second defendant. It's a reasonably small amount, but you want to have about, towards the end, the last full paragraph on that page, it was resolved.
Yes.
It was resolved that the sum of almost £5,000 be accepted as a loan from Essam Al Tamimi, the terms of the loan being unsecured, interest-free, with no specific date for repayment. So that's the first one. Then over the page we have another one.
Described as a loan.
Yeah. So this is the directors of the company. These are independent individuals, and so they can't be impugned because these are the continental directors, the Jersey independent directors, agreeing that the money that's been advanced at that point is a loan. So that's a start. These are the first few payments that are made. Over the page 314, there's another one, 1832. I believe 315 is a repeat of the first one we've seen, so we can cross out. We can move on from there. And then if we go forward, please, to page 318. You see there another similar document in relation, I think it's to Jorum.
Yes.
Limited 2738. So these are quite small sums. But then on page 318A, Your Honour will see this is again the second defendant. And the larger sums, there's two sums of 205,000 and then 444,000, nearly 445,000. And after consideration, it was resolved the sums of that be credited to the loan account of Mr. Essam Al Tamimi and the registered company, being noted that the loans were unsecured, interest-free, with no specific date for repayment. Then 318C,
Yes.
again the second defendant, it's another payment recorded in similar terms, 17,125. Then at 318E, there's another payment, 1,832. Then at F, this is again the second defendant, 26,841. Then at H, H is another payment, 25,662. Again, these are loans. And J, 4,793. I think that's it. Now, I've probably added them up wrong, but I make it about £7,700 to the first defendant. So payments for and on behalf of the first defendant recorded as loans in these documents. On behalf of the second defendant, 733,124 is my calculation, but I may well be wrong about that. The point is that the company books, at that stage at least, are treating these payments as loans from the outset. And they are treated in the accounts of the companies in exactly the same way throughout. So all of these payments end up in the same place, the ones that are dealt with here and the ones that come after. They're all under the heading Rules in Current Accounts, which has been interpreted as meaning that they are loans given by Ms. Al-Shamar to the company. But that interpretation is clearly a misinterpretation, because we can see from these documents that what ended up in those loan accounts are just indisputably loans from the claimants. Now, at some point, the directors of the defendants change, and then you have no more directors' resolutions of these sorts after that time. But the payments continue to be recorded in exactly the same way. And Mr. Al Tamimi makes the point that all of this ultimately, when one looks at those accounts, all of that comes from his own accounting records, which record these loans as well. So they're contemporaneous documents. They're not before the court. There are contemporaneous documents from Mr. Al Tamimi which show all of these being recorded as loans from him to the companies.
So the sums we are dealing with here, the claim for, are not supported by those resolution, the board resolution, right?
Yes, they are. All of these sums are in...
The claim amount, the claim sums right now,
Yes.
are not supported with the resolution, right? Because the director...
Correct. Not all of them.
Not
Only the ones I've... Well, say for the resolution that comes later, which is in July 2014, which is the disputed one. No, I think I've shown you on just the only ones that come from the beginning, so there are no further resolutions subsequent.
Yes.
And then in 2012 what happens is that the first defendant, this isn't disputed, repays almost £3.2 million to the claimant. So if the test is, what were the parties expecting to happen to this money when it was paid over by the claimant? Was it a gift or was it to be repaid? Well, if it was a gift, why is £3.2 million being repaid to the defendant? It just makes no sense for that to happen. And then the claimant and Ms. Al-Shamar separated in 2012. So they stopped cohabiting as spouse, as husband and wife. And so from that time, the payments just can't arguably be gifts, can they? They've fallen out. They're not now husband and wife. So it's argued that all of these payments are gifts. That's the position of the defendants. But they've separated by 2012. So, and yet the defendant, the claimant is still supporting the companies financially. And then, as I say, you have the loan agreements themselves, which come in 9th of July 2014, in which there is an agreement, and even if it's not binding, it shows the intention of the parties at the time. Is it a gift? Is it a loan? And clearly at that point, you've got a written document which just shows that all the payments, at the least after that date, must have been intended to be loans and not intended to be gifts.
But that fact a little bit, confusing me, because my understanding the claimant wasn't in a good relationship with his ex-wife, of course, after the divorce, and why he would still continue paying loans to the company owned by the ex-wife.
At that point, he still thought that he owned the companies.
So
Because the question of whether his wife owned it or he owned it wasn't decided until February.
yes.
So at that point, he thought he was still entering into, in the normal way, shareholders' loans to his companies. Now, that makes sense. What doesn't make sense is that they fall out, and then in fact in 2015 they get divorced, and the case is still, oh no, these are still gifts. There's payments made after the divorce. That doesn't make sense.
You made some point as well, your argument about those payments came from the UK banks or from some of the banks. You was referring to your skeleton argument, your submission.
I think...
You pointed that those loans came from UK.
Yes, correct. So
I don't know what's your point in that?
So my point there is simply that Mr. Tamimi says that in order to make these payments,
yes,
he took out loans.
Oh, all right.
And so he didn't just have cash lying around, which he applied to the companies. He took out loans to make the payments. And what I say about that is that if you're taking out loans to make payments, then you're expecting the money coming back so that you can repay it. So
My confusion point here, he took loans from the financial institution UK to cover that loans. And of course the loans, when he took it from the UK bank, should be paid with interest. But when he gave the loans to the company, it was loan free of interest.
yes.
Which is, for
So
me,
he's
it's not commercial, if you like.
Yes, I'm not suggesting that there's an arm's length relationship. So it's not like he's a stranger to these companies. He thinks he owns the companies.
Right.
So and it's not unusual for a shareholder or somebody who thinks they're a shareholder to support a company financially with interest-free loans.
Even though he's paying interest to that.
Yes, wherever the money comes from. No, it's right. He's left out of pocket by all of this. But my short point on that is simply if he's borrowing money from over here to make these payments, he knows that money has to go back, and so that supports the conclusion that he's expecting to get the money back. But that is what the documents show. But the point about the loan agreements is that if he's making payments after he's actually agreed these are going to be loans,
Yes.
it's not arguable that those payments were intended to be anything but loans. It's not arguable that they could be gifts when he said in a document these are going to be loans. That's what the loan agreement says, effectively.
Do you have sort of evidence to support that? In fact, he Al Tamimi took loans from a bank to, or just as a statement?
It's in his witness statement.
Yes. That's fine, just for my clarification. Don't need to.
Could you just write down the reference? I'll give it to the judge. Thank you.
Yeah, we can.
I'll provide you on with the reference. Yes, I see. Yeah, I'm told it's an overdraft facility. Sorry, that's I'm getting.
Overdraft.
I assume that's paragraph numbers. Yeah. So paragraphs 31 and 43 of Mr. Al Tamimi's second witness statement,
Al Tamimi's second.
which we'll find at tab 8 in bundle 2. 31. Thank you. Paragraph 31 on page 296. Thank you.
Overdraft.
So leave the loan agreements aside. Were these loans, or were they gifts? And the reality is they're treated as loans at the beginning. They're loans at the beginning. They're loans at the end. If there were to be any doubt, it could only be in relation to what happens in between. But it's all treated in the same way in the company's books,
And has been repaid partially.
and has been repaid partially. And it's in that context that it said, well, the loan agreements are shams and fraudulent documents. And my learned friend, at least on paper, it had been put in two ways. It's been in a slightly different way now. The first way it was previously put, at least, was that Miss Wunsch, she was a director until 2014 of both defendants. She was removed as a director in 2014. And then shortly afterwards, she signed the loan agreements. So the first point was made, well, she didn't have authority to sign the loan agreements. But the point on this is that neither Miss Wunsch nor Mr. Tamimi, Mr. Al Tamimi, were ever shown the shareholders' resolution removing Miss Wunsch as a director. They weren't shown that until a year later, on the 1st of May 2015. And we have evidence that what happened was her lawyers sent the resolution to STM. We have that at bundle 2, tab 11, page 439. And then STM subsequently were asked, well, did you forward it on to Ms. Wunsch? And the answer came back, no, they did not. Why? Well, because they assumed she knew all about it. And that email is at bundle 3, tab 15, page 671. And so their evidence, which is consistent with all of that, both from the claimant and Ms. Wunsch, is that they didn't see that document until the 1st of May 2015, when they turn up at the property, one of the properties in London, to change the locks, and she says, oh, no, you can't do this because you're not a director anymore. I've removed you, here's the document. And the reference, that's also in Mr. Al Tamimi's second written statement, paragraph 19 this time. Mm-hmm. But in the meantime, because he doesn't know that this has happened, and because he has the comfort of the loan agreements that are in place, yes, he continues to fund the companies.
And the company continue to receive those funds?
The companies
without
continue to
questioning
receive the funds.
Based on what? And you just mentioned that in some occasion where after signing those, after the 9th of
Yeah.
July, there's an email sent to...
Yeah. So let's look at that, because it's quite important. It's bundle 2,
reply
tab
to
9.
those.
Tab 2, bundle 2, tab 9, page 325.
Bundle 2.
Tab 9, page 325.
Yes.
So if you see at the bottom of page 324, there's an email 27 July 2014 from Dipali Maldonado, that's on behalf of Mr. Al Tamimi, to Kevin Shells, Una Smith, Rachel Bunch and Banal Kudar. Una Smith...
Are we reading from 331 or
324. So firstly, dear Kevin, I write on behalf of the directors of the above-named company. Please find attached for filing in the statutory books of each company board minutes, loan agreement and financial audit report. Kindly acknowledge receipt of this instruction and confirm once the attachments have been filed. And then that is to STM Jersey, and that is forwarded on to Ms. Al-Shamar's lawyers in Jersey, OGA. So that's Dear Emilita, I hope this email finds you well. The email below was received in relation to the above-mentioned companies with the attached documents. Mr. Al Tamimi has now put in place loan agreements for the funds which he has remitted to these companies. And then there's an exchange because one of the lawyers had moved on, but it no doubt finds its way. And then a year later, you have the winding up petition in London, and that is on page 323, where STM email Ms. Al-Shamar's Jersey lawyers. In relation to Jorum Limited, I can now confirm there's been a development in relation to the outstanding loan with Mr. Al Tamimi. Please find attached an email and letter received from Kennedy's Law, LLP, which is demand for immediate payment of debt due. I'd be most grateful if you could pass this information over to the sole shareholder so that she is fully aware of the situation. Also make the directors of Jorum aware of this demand for payment of debt. And it's at that point that they come back and say, then there's the winding up petition and the argument about that. But certainly in July 2014, the loan agreement was made known, not just to the then directors of the company as they were understood, Mr. Bunch and Bang Shmar, but also it's sent on to Miss Al-Shamar's Jersey lawyers.
But not herself. I mean, we don't have any sort of evidence that she know about this agreement.
Well, we can't see what goes on behind the scenes of lawyers, but the lawyers are being sent a document which says, here's the loan. I don't know, maybe
the lawyer sent the document to her email, is that right?
Yes. And the subsequent documents clearly are sent on to her. But during that time, you have the companies continuing to receive payments and continuing to have certain debts paid off by the claimant as a result of that. So what I would say about that is even if there was an argument about whether the loan agreements were valid, they would, by all of this, have been ratified in any event.
Who became the director of the company after?
So what happened was that she, Ms. Al-Shamar, in 2014, she signed a shareholders' resolution removing Ms. Bunch and Ms. Van from the directorships and appointing herself as director.
That's acceptable in Jersey?
Well, as I understood it...
as a shareholder to become an executive?
I don't think there's a problem with a shareholder becoming it, but I think that the Articles of Association of the company required two directors. And so at the same time that she was seeking to have herself appointed and the previous directors removed back in 2014, she was also trying to change the articles of the company to permit there to be a single director. I'm not sure whether or not her directorship has now been registered, whether it has or hasn't, but that's the position. But the point for these purposes is that certainly Ms. Wunsch continues to believe, and there's no evidence to suggest that she was told otherwise, that she was a director of the company.
Yeah.
The point now made today is, well, this is all about power of attorney. So the claimant also had a power of attorney over the companies. And that was cancelled, and he knew about that. But that's a separate issue. Because the question about whether this is binding is firstly whether or not Ms. Wunsch was authorised to bind the company, whether she was actually a director, or whether she was held out as a director, so it's the apparent authority. Because if nobody knew that she'd been removed, then she continues to have the authority she was given previously. The next point is that this is just simply such a bad, well, effectively she can't have been acting in the interests of the company when she signed these loan agreements. She must have been acting in Mr. Al Tamimi's interests. But there's a clear reason to enter into these loan agreements. The payments were either loans or they were to be repaid on a restitution basis. Because you can't just keep my money. If I give you money, whether we have a contractual agreement, I give you money, then generally speaking, it will be implied that you have to give it back again. Similarly, if I pay third parties, if I pay your debts to third parties, then as long as the court can see, either expressly or impliedly, that you've requested that I do so, then you're going to have to repay me for that, whether in restitution or as an express or implied loan agreement.
The repaid amount from the defendant to the claimant was based on the request from the claimant to the defendants with kind of like a period of time to be repaid or with conditions or... I'm not clear with that.
On demand is the way...
Yeah, but what happened? I mean, the loan agreement say on demand, I understand that. Yeah. But what happened in action afterwards? So the claimant repaid some of those amounts. Whether the claimant can show that he requests X amount to be paid within a period of time, or...
Well, if it's repayable on demand, all he has to do is say, give my money back.
Yeah.
And if we just leave it, I mean, by these proceedings, he's claiming the money back. So
No. I mean, the fact that the claimant, the defendant did pay back some amount.
Oh, I see.
Do we have any kind of procedure to capture that proceeding? I
don't think have detailed evidence about how that arose, I'm afraid. We don't have that. It's an informal arrangement, that's certainly true. But there we are. But there's no dispute that it was repaid. Yes. And that's in 2012.
Yeah, it was repaid as a loan, as a paying back the loan, or repaid as another arrangement. We don't know.
It's not suggested that it was some sort of separate arrangement, I don't think. It's just not explained. What I'm saying is that it's consistent with these being loans, and it's inconsistent with them being gifts. It's not said that Ms. Al-Shamar, in her generosity, gifted back £3.2 billion to my client. That's not the case that's being put.
All right.
So the point is that, yes, that even if there were doubts about the basis for these payments, at the point in July 2014 when the loan agreements are signed, there's nevertheless two very good reasons to enter into those agreements in the interests of the companies. Reason number one is, on some basis, and there's a very strong case, say an indefeasible case that these were loans, but even if they weren't, there's going to be some other legal basis for repayment. But the second point was that in return, the defendants got further funding. They got further funding from Mr. Al Tamimi. They needed that money to carry on paying the banks and all the other benefits. Your Honour was taken to the release document. Again, I won't take Your Honour back to that.
Just briefly, if you like.
Very briefly. Firstly, it only applies to a small part of the loans to the first defendant. It's a small number. It precedes the loan agreements. So if the loan agreements are correct and can be enforced, then that document is superseded by them. But the main point here is that they are part of a deal which didn't proceed. And what was happening was that the first defendant was going to be sold to a third party. And so the third party wanted comfort that Mr. Al Tamimi wasn't going to come back afterwards and say, yes, I've sold you this company, but now I want all my money back as loans. And as part of that same transaction, all of the proceeds of the sale were going to come to my clients. And the document for that is Bundle 2, Tab 8, page 319.
Which it took place in 2012?
2012, correct.
Which is the exclusive jurisdiction.
That's the one that contains the exclusive jurisdiction.
Okay.
And the point there is that the only loans that are dealt with in that are the ones that appear in the director's resolutions, because that is what a third party would be worried about, because that's what's recorded in those resolutions. So what I say is that when one actually looks at the claim itself, there's really no real prospect of defending on the merits, because firstly, parts of it are just obviously wrong, and of course Your Honour doesn't necessarily have to make a binary decision. Your Honour could say, well, parts of this claim have their arguable defences, and so we'll allow those to proceed. Other parts there are no arguable bits. But in relation to parts of it, they're just obviously wrong, because I've shown Your Honour the director's resolutions, which record the companies agreeing that these are loans, and then you've got the payments that are made after the loan agreements, and even if those loan agreements fall away, well then those would be payments made pursuant to a void contract, and so they'd be taken federal consideration, so there'd be a clear restitutionary claim for those. And my claim wasn't put just on the basis of the loan agreements. There was a restitutionary claim, not fully particularised, but it was in the claim form. That is the way the claim would be advanced if it had to be. So the bits that come in the resolutions and the bits that come after the loan, there's no arguable defence to any of that. But effectively, everything that comes in between is just treated in the company's books in precisely the same way. And ultimately, it'll come down to what's the intention of the parties, that these should be loans, that these should be gifts. And if he's making payments after 2012 when he separates, it's just very odd, it's very strange if he's nevertheless still gifting. If he's nevertheless still gifting, even after they get divorced. So what the defendants are currently saying, they don't major on these sorts of real prospects of success. What they're saying is, let us reopen this judgment. Because if you do so, we can then run a series of procedural points which would actually prevent this court from looking at these issues in detail, prevent the court from actually reopening those elements. And those are points, res judicata and also abuse of process, those are points which have arisen since these proceedings commenced, since this case was decided. Ultimately, the abuse point in particular comes back to a forum non conveniens argument, which should have been raised or could have been raised back when the judgment was issued. That's what I have to say about the test. And I can also deal with discretion, and I'm aware of the time. I'll see if I can finish in the next 10 minutes. So even if Your Honour finds that there are grounds to set aside, then Your Honour still has a discretion, and at the centre of that is the question of promptness. But I'll deal first with what my learned friend says about concealment. He says that these proceedings were concealed from his ultimate client. I say that just doesn't stack up, because as we've heard, by the time the proceedings were commenced, Ms. Bunch had been dismissed as a director, and she says she thought that the proceedings would be sent to Ms. Al-Shamal. That's what she thought would happen. She says that at paragraph 10 of her witness statement. Now, that, I say, is just totally reasonable. My learned friend says, on the one hand, Miss Al-Shamar hasn't been called for cross-examination, but on the other hand, he can stand up and call Miss Wunsch a liar. Well, one has to deal with them consistently, and the reality is, in these sorts of applications, the court is entitled to draw inferences, factual inferences from the evidence that it has. And what I say is that it's totally reasonable that Ms. Wunsch thought that these documents would be going to Ms. Al-Shamar. The first point is that the loan agreements, as we've seen, were forwarded in 2014 to Ogier, the claimant's Ms. Al-Shamar's solicitors. The second point is that the winding up proceedings from London, they were also forwarded on and found their way to Ms. Al-Shamar. So in exactly this route, the previous proceedings went. The email for that is at bundle 2, tab 9323. The judgment, so there's then, after that, obviously the claim is issued and served, and then there's a further chase on the 1st of September by my solicitors, saying we'll give you further time to respond. And those two documents, it said, didn't find their way to Ms. Al-Shamar. If that's right, they're the only two documents which didn't find their way to her, because then what happens is the judgment comes out and is sent to the defendants and is forwarded by STM to Ms. Al-Shamar. So she gets that on the 19th into her inbox on the 19th of December 2016. You want to has that at bundle 1, tab 5, it's 164.
Yes.
Then my client starts enforcement proceedings in England. Those enforcement proceedings are sent to STM and they find their way to Ms. Al-Shamar. And then, so what happened is literally every relevant document went to Ms. Al-Shamar, save for, it is said, the claim form in these proceedings and the letter of the 1st of September 2016. So there are 2 points here. First point is the idea that Ms. Wunsch knew that these documents wouldn't go to Ms. Al-Shamar just simply is just doesn't survive that analysis, because she's seen that everything went to Ms. Al-Shamar before, and in fact that was a totally reasonable assumption for her to make. And the fact, she explains the fact as to why she personally didn't want to communicate with Ms. Al-Shamar. And I say that's unsurprising. She'd been dismissed and she'd been accused of all sorts of things by Ms. Al-Shamar, including making criminal complaints against her, which she says totally unfounded. She just wanted nothing to do with it. And so in those circumstances, she just didn't get involved. She was entitled to do that. She owed no obligations to the other parties, and she assumed that the documents would get to Ms. Al-Shamar. And the fact that she received the document herself didn't indicate that Ms. Al-Shamar wouldn't receive the document, because the documents had been sent separately to them both previously. So there's just nothing in this allegation that Ms. Wunsch somehow hid this. It's totally inappropriate, it seems to me.
Yeah. The loan agreement was signed in 9 July 2014.
Yes.
Then you said the claimant or the director who signed this, I think the director get to know that she was removed.
Correct.
When did she know that? 2015?
Yes, 1st of May 2015.
Then after that date, 1st of May 2015, the claimant continues paying the payment, the loan to the...
Yes.
Now this is the question. That should come to the claimant understanding that the document he signed with the person might be not anymore binding because that person now is removed. So why he would continue paying those loans, taking the risk? You get my point?
Yes, but I think that the point arose at or around the time of the winding up proceedings in London. Now, at that point, so when one looks at it from that perspective, it's not a question of the loan agreement not being binding anymore. It's a question of was it binding at the time.
Yeah, but I was talking continue paying any further payment. So, my point, after 2015, when the claimant understood that the person who signed that loan agreement is not entitled to do so, he was removed or whatever, but he would stop paying any further payment because that will make a risk for.
I hear what you're saying. I don't think there's any evidence as to why he, specifically as to this point, I'm told the reason.
2015.
Yeah, no, but I'm told the reason is that he took legal, well, that he was relying on the ostensible authority, as the apparent authority, of Miss Wunsch at the time.
Yes.
So if you don't know if someone has been dismissed as a director until a year after, then everything that happens in between, the company's still bound. And there's no suggestion that, well, my clients say they didn't find out about this until the 1st of May 2015. And if that is right, there's no answer to the point that Ms. Wunsch remained authorised, apparently authorised, to enter into agreements on behalf of the defendants.
So the last payment your client made to the company, when exactly was?
That would have been 2016, I believe.
So 1 year after.
Yeah.
So soon.
But the point there is this, that firstly, if he continues to make the payments, he does so on the assumption that there were valid loan agreements. So imagine that's wrong. Imagine that's wrong. Imagine that's, yes, but the question of authorisation comes at the time of signing the document, not later. But if he continues to make the payments when he finds out there's an argument about these documents, then he's doing so on the basis of contracts. And if it's shown that those contracts don't actually exist, then he will nevertheless have a restitutionary right, a right of restitution to recover those payments. Because if you and I contract for some reason, say we enter into a loan agreement and I advance you on some money, and it turns out that we're not allowed to enter into a loan agreement because the loan agreement is void because you have to be regulated, say. You don't get to keep the money, I'm afraid. I get to have my money back. Not as a loan agreement, not under the contract. Why not? Because the contract is void, but at restitution. So I get my money back. I don't get the interest that we agreed. So say I require one to pay the interest. I'm sure it would never happen. But say that happened, I wouldn't be entitled to recover that, but I'd still get my money. So there's no risk of continuing to pay, which is founded on the non-existence of the loan agreements from 2014. Makes sense? Because if I can't recover under the loan agreements, I can certainly recover in restitution.
Okay.
So you want to, when one looks at this question of whether or not Ms. Wunsch concealed these proceedings, that's the first point. Everything else had gone. The second point is that the claimant's solicitors tried again on the 1st of September 2016. So they sent a chaser. And why on earth would they do that if their intention was to conceal these proceedings? And frankly, the evidence on what happened to that document, on that letter, is completely unsatisfactory. It's a bit of a mystery, what happened to that. We have to look at what Ms. Al-Shamar says about all of this. The first point is she says the claim form, she didn't get it. STM only sent it to Ms. Wunsch. And then second, in relation to she says the first thing she saw was this February email serving the English proceedings. So she didn't find out about all of this until the 27th of February. So what happened to this letter of the 1st of September, or the email of the 1st of September 2016? What happened to it? We don't have anything from STM directly. So that email was sent to STM. Ms. Craig, her evidence on this is that STM have not been able to ascertain if these were forwarded on. That's what they say. That's paragraph 52 of Ms. Craig's statement. Under 1, tab 4, page 27. So the defendant's evidence from Ms. Craig is that STM don't know, they can't say if these were forwarded on. That is bizarre, frankly. I mean, it's going to be in someone's sent box or it's not. So it must be clear, it seems to me, whether or not they did or they didn't. So we're not getting a complete picture of what happened on the 1st of September 2016. Then we have the judgment that is served in December. And that did go to Ms. Al-Shamar's email.
Default judgment.
Yeah. So she gets that into her inbox. And again, her evidence is, I say, unsatisfactory. She said she overlooked it. She doesn't know why. She explains that she was busy at the time. She didn't read it. She doesn't know why. She certainly didn't react to it. But the heading of the email is Jorum Limited Court Judgment. It's going to jump out from in your inbox, and it's very hard to see how someone could miss that. Your Honour will note that that document, that email, went to the same address that Ms. Al-Shamar has put on the application notice in these proceedings. So she's copying. So would it be sufficient for this court if she said, "Oh, I'm sorry, I didn't get notice of that court hearing, I just didn't happen to see it"? And we might have a better understanding, we might be in a better position to assess this if we knew how many emails she sent that day and how many she received that day. She says she wasn't checking her emails regularly, but what we do know is that she was using that account on the day and responding to emails on the day, because we have an email in which she corresponded with the claimant on that day. It was in the morning, and the document was sent to her in the evening, or the afternoon. And we only have one snapshot of her inbox and outbox, because that's all we've been involved in, but it hasn't been produced from the other side. So the email is at Bundle 2, tab 9, page 410. And now, my learned friend spends quite a bit of time in the evidence and in his skeleton argument, complaining about the credibility of my clients and my witnesses. But all that matters for the purposes of this issue is the credibility of Ms. Al-Shamar. Can the court simply accept she didn't see that? She didn't see that email. In that regard, I mean, pleasure in advancing this evidence, but there is evidence that Ms. Al-Shamar doctored an email exchange previously. I'll give you another reference, and you can take from it what you will, but it's not responded to in her evidence. There are two allegations. One is that she amended an email to make it look like something had been sent to her which hadn't. She added some emails in. It was relevant to some other issue. The reference is paragraph 13, bundle 2, tab 8, page 289. And then it's supported by an independent expert report at bundle 2, tab 9, page 339. She doesn't say this didn't happen. There's also an allegation of hacking, and the evidence on that is much thinner, so I won't go there. And there is a response, and she does say she didn't do that.
I don't want to hear that.
No, I accept that. That's fine. But my point is not that you should rely on that. My point is she responds to that allegation, but she doesn't respond to the question of doctoring email exchanges. So my submission on all of this is that there may have been a mix-up. There may have been a mix-up with the claim form. If there was, it was STM's fault. STM was the defendant's agent, at least for the purposes of receiving the documents. There's been no satisfactory explanation about the 1st of September chasing emails. I say it would just be a huge coincidence if those were the only two documents which weren't forwarded on. There's no satisfactory explanation about the 19th of December email when she saw this. She simply says, I didn't see it. And and then instead of saying, I should have done this, she blames it all on Miss Bunch and says that it's all a great conspiracy to try to conceal things from her. I say the court is entitled to conclude that she chose not to respond until the enforcement action in London. It wasn't until then that response was triggered. So until she saw the London court proceedings. Yeah. So it's not until my client takes proceedings in London to enforce the judgment from this court that she responds. So as it gets closer to the assets, which are all in London, it's at that point that she comes back. I say that it's just as likely that is what prompted the action. She saw it getting closer. And if so, then that is not prompt response, and it shouldn't justify setting aside. And then the next point, is the one my learned friend was dealing with at the outset. Even then, when this becomes known on the 27th of February 2017, even then, so she now knows that the companies failed to respond in August, the companies failed to respond in September, she missed an email in December. Even then, she takes 7 weeks to make this application. And in the context of this claim, I say that's simply too long. Because this case would be over by now if the defendant responded. The case progression plan would have us having a trial in July. And instead, if the defendants have their own way, it will have only just begun. And they say they're entitled to rely on things that happened since, the judgment in Jersey since. Those are reasons not to reopen this. And my learned friend relies on the consent order in the London proceedings. But the point there is two totally different things going on. There was so what the consent order did was it stayed the English enforcement proceedings so long as the defendant took steps to make the set-aside application within a certain time. What it did not do is make any agreement about the impact or further delay, or delay up to that point. This is already really March at this point, late March. It didn't affect my right to come to this court and say it's been 7 weeks. 7 weeks is too long. Ultimately, it's a matter for your honour. I say at that point, 7 weeks is too long. And in a sense, that is the easy answer to all of this, in my submission. Regardless of all those points, it's not prompt. And I say it would be unfair when, A, the result would be that the defendants will come back and they'll rely on the Jersey judgment, so they'll be able to take advantage of all this delay, or they'll argue that it's abusive, again, and take advantage of delay, and because the claimants already spent money enforcing in London. And so if they get set aside and they win at the end, we'll have wasted all that money in London because they didn't respond to the claim. That's why I said at the end of my skeleton argument that if you were to allow us to proceed, it should be on terms that they compensate us for the wasted expense of that. I know, for instance, you don't have jurisdiction to do that. Of course you do. You can impose whatever conditions you like. It's in the rule, 14.1. Impose in 14.2, you can impose conditions on setting aside. But I say we don't get there. And very finally, my learned friend said, well, if you allow this claim to proceed, it will destroy the Jersey judgment. That doesn't follow at all. We're talking about London property here. London property in respect of which there is an offer on the table at the moment of £14.5 million, which is, I'm told, almost twice as much as it was bought for. So the companies keep the increase in the equity and just have to pay back what was paid to third parties to fund that. So it wouldn't destroy the value of the company at all. Your Honour, I've gotten too long, unless there's anything I can help further with.
Thank you very much.
Thank you.
Would you like to reply? Maybe 10 minutes? 15?
If you can take 10 to 15 minutes off me, then I'll do that now.
Will we finish exactly 1:30 unless you want to have another round? Or? This might be.
No, I hope I
this is
won't
like
need
a
one.
2 hours application. So
Yes, no, exactly.
Yeah.
Quite.
Right.
So, by way of reply, I'll deal with abuse first, and the idea that this is somehow new to the claimant based on my skeleton. First of all, I would say that Mr. Al Tamimi knew or ought to have known or should have been advised that it was abusive to issue here when the Jersey court was seized of the proceedings, when he issued these proceedings. So Your Honour should have no sympathy for him there. Secondly, just as he did not tell the Royal Court in Jersey about issuing these proceedings, which was held to be a material non-disclosure, he didn't tell this court when he applied for the default judgment or when he issued the claim about the proceedings in Jersey. That's a material non-disclosure too. That's obviously abusive. He knew about it. And it's wrong to say that the first that's been said about abuse is in my skeleton argument. For your notes, and I won't take you there now, Laurie Craig's statement, her first statement, deals with abuse. She doesn't refer to it as an abusive process, but she calls Mr. Al Tamimi's conduct in issuing these proceedings, quote, astonishing and disingenuous. So that means dishonest, for the avoidance of doubt. In respect to my learned friend, he's, if I may say so, dealt with the abuse argument admirably. And Henderson is an authority from the 1800s, and the principles to which I've referred are time-honoured. So he's dealt with them ably because he was able to do so. In respect of jurisdiction, there can't have been any surprise there about that argument, because, as my learned friend fairly pointed out, in Laurie Craig's first witness statement, it says, we don't accept this court has jurisdiction. Those points will be addressed by counsel at the hearing. I've done that. They're legal points. In respect of the loan contracts, I want to clarify something. If I didn't make it abundantly clear, I apologise, but I distinctly recall saying that the claimant's case, the claimant's primary case, in my learned friend's words, is that he relies on the contracts of the 9th of July 2014. I don't accept the validity of those contracts. I say they are a sham, on the same basis that is set out in Advocate Blakely's skeleton argument, which I would invite you on to read if you haven't already. My position is this, and it must be right. If my learned friend wants to pursue a primary case on those documents, he has to accept what they say, and what they say is binding. He went on to say, and quote, a jurisdiction agreement always involves a submission to a jurisdiction, unquote. Well, it does not. The purpose can be the opposite. So the parties can say, in a contract, we agree we do not submit to the jurisdiction of Mauritania, for example. A non-exclusive jurisdiction clause could say the courts of Jersey or London have non-exclusive jurisdiction. This agreement, of course, doesn't just say that. It says the lender submits to jurisdiction. But the better point is Ronna's point, which is that, as well as having said he submits to jurisdiction in those contracts, he had submitted to the Jersey jurisdiction a year before the proceedings here were issued. So just a clarification now. The claim in Jersey was to beneficial interest in shares. There's no dispute about that. There was also an unjust enrichment claim, which I'll come back to in a moment if I may. The directors' resolutions to which my learned friend has referred were before the court. The July loan agreements were before the court. The fact that Mr. Al Tamimi had continued to make payments after the divorce was before the court. His evidence on beneficial interest in the companies was disbelieved. His evidence was, well, I continued making these payments because I was the beneficial owner, I was the owner of the company. He was disbelieved. And it's not right to say that Laurie Craig says only evidential weight should be attached to that. The court made factual findings on the loans, and she sets that out at paragraph 4510 of her statement. It's not confusing in my respectful submission that he went on to make payments after the divorce. My learned friend rightly points out that it's his case that he thought he was the owner of the companies. I would make a slightly different submission, which is that it supported his case to continue making payments as if he were owner. Furthermore, the continuation of payments prevented the banks foreclosing. These companies owe money under mortgages to SG Hambros and Coots, and so continuing to pay prevented the properties being taken away by the banks. So there was a simple justification there. What the court finds in its judgment is that the money might have come from Mr. Al Tamimi in the first place, but insofar as the companies and the companies' records are concerned, they were loans
from Mazal Charma. That's the finding, and it's a finding of fact which has not been appealed. So one, I submitted earlier that the proper course would have been to raise this as per Henderson, as per Aldi, in the Royal Court of Jersey proceedings. But if he disagreed with that finding of fact on the loans, then he could have appealed. Coming back to waiver, my learned friend says the waiver comes before the loan agreements. You'll remember it was dated February 2012, so I can't get home on that. Well, no, that's wrong. Because his client's case is that all that the 2014 loan agreements did was formalise the agreement. And I'll take you to the pleadings, Your Honour, which are behind tab 2. Sorry, tab 1. Forgive me. Tab 3, obviously I am tiring. Brief details of claim, page 6, behind tab 3. Pursuant to express and or implied contracts of loan, the claimant paid the following sums to the defendant and or to third parties on behalf of the defendants during the period 3rd of July to 2nd of July 2012. So the waiver goes to those loans because it was dated 2012. So it's wrong to say I can't get home on that. Just in terms of helping you on the loan agreements, the court in Jersey deals with the Coots loan and the SG Hambros loan at paragraphs 10 and 29 of its judgment. I don't believe there's any factual dispute between the parties as to the nature of those loans or the way in which they're repaid. Your Honour raised a question with my learned friend, which was phrased something like this. The abusive process argument is difficult here because it involves two different jurisdictions. I took Your Honour to the case that answers that question, which is reset the House of Lords decision, and so I'd invite Your Honour to have a look at that and to have a look at Henderson particularly carefully. Learned friend talked about ostensible authority and the shareholders' resolution and the fact that Ms. Wunsch didn't know she was not a director when she entered into the July 2014 loan agreements. Well, two things about that. She only ever acted on the instructions of Mr. Al Tamimi. He had power to give those instructions based on the power of attorney given to him by my ultimate client, as my learned friend described it, Zal Charma. That power of attorney was revoked in May 2014. Ms. Wunsch knew that, Mr. Al Tamimi knew that. She always acted on his instructions. So whether she knew she'd been removed as a director or not, does not matter, because Mr. Al Tamimi was standing on both sides of the transaction. He had no authority to tell her what to do for the company, whether or not she's a director. Key documents for your note are, in fact, the key letter is a letter from Ogier, who's my client's then lawyer, tab 5, page 75 to 76. Page 75 to 76. Okay, and that's a letter from Ogier, 29th of May 2014 to Rachel Wunsch at Al Tamimi Investments. And it's the antepenultimate paragraph that is the key paragraph, which says this: Mr. Al Tamimi was granted a power of attorney in December 2007. This power of attorney has since been revoked. What the court said about Ms. Wunsch's actions in its judgment is at paragraph 71 of its judgment, and it described her actions as, quote, surprising, unquote, in circumstances in which she knew about the dispute over the shareholding of the company. You can see that Ms. Wunsch knew about the revocation from pages 682A (75) to 77. She knew about the dispute. So the point is that Mr. Al Tamimi, the claimant, had no power to instruct her to do anything for the company. So whether or not she didn't know she'd been removed as a director is neither here nor there. In respect of unjust enrichment, the court dealt with this in respect of the claim against Mazal Charma in the Jersey court on page 68 behind tab 5, and that's paragraph 106. And it said she has not been unjustly enriched by Mr. Al Tamimi because I want to quote this absolutely correctly.
So the loans came from the bank.
No, it says this. Accepting as we do that the defendant, Mazal Charma, made no financial contribution to the acquisition of the London properties or the incorporation of the companies, it seems to us one can say she has been enriched at the expense of the plaintiff. The question which next arises is whether that enrichment is unjust. We do not think it was. The court has found that the defendant, Mazal Charma's explanation of how the transfer of assets came about is a credible explanation on the balance of probabilities. Goes on to say, this part of the defendant's evidence was not tested in any substantial way in the cross-examination. In the circumstances, it appears to us to be a complete defence of the argument she has been unjustly enriched at the expense of the plaintiff. Now, that's a claim against her for unjust enrichment. What's being advanced here is a claim against the companies for unjust enrichment. But in light of the finding that the companies, that the money came from Mazal Charma, however it came to her, it's a complete dead end, and that's explained for the court in Laurie Craig's witness statement behind tab 12, page 589, on paragraph 42. In terms of the allegation of secrecy, service of the proceedings, there's a finding of fact about that already in the Royal Court of Jersey, which I took Your Honour to, page 600 and 601, which says Ms. Wunsch knew that the documents were not going to be forwarded to Mazal Charma. I rest my case on that, and it's frankly pathetic for the claimant to rely on the fact that Ms. Wunsch and Mazal Charma weren't communicating, or Ms. Wunsch didn't want to communicate with Mazal Charma. The feeling is mutual, I can assure you, but there have been armies of lawyers involved in this case, and Mr. Smith, who sits to the left of my opponent, quite easily have taken instructions from Rachel Wunsch to simply send the proceedings to Laurie Craig. It's part of the point of having lawyers that the temperature is taken out of disputes. STM's position is obviously problematic for STM. It's no wonder that they've sent a cagey response in the circumstances saying we're unable to ascertain whether or not we forwarded these documents to Mazal Charma. I'm sure if they could find an email showing that they forwarded the documents, they would have sent it to us. That they may be in difficulties, let me put it that way. In respect to the doctoring of the email, my learned friend is right to say the allegation of the doctoring of the email against my client. My learned friend is right to say it's not responded to in Mazal Charma's evidence. It is responded to in Laurie Craig's evidence, at paragraph 28 of her statement behind tab 12, page 582. So I'd invite Your Honour to read that. And nothing more needs to be said about it. I should say the key point there is that evidence was before the Royal Court in Jersey. My client's evidence was believed. Mr. Al Tamimi's account was not believed. He was found to be a person who, it could be surmised, would hide assets from or try and take them back from Ms. Al-Chana.
The only questions I have for you, which is still I don't have an clear answer from your side, is those underlying documents, which is called loan agreement. First of all, why it's called as a loan agreement, as a loan, and why it's mentioned during within the text of the document that it has to be paid on demand if it is has no binding status, or it is meant to be just a gift money from the claimant. First of all, in your position, you reject the fact that the claimant paid anything to the company, right, to the defendant.
Well, I've not seen any. No, not at all. I mean, it's accepted that my client made no financial contribution whatsoever to the companies. That's accepted. I mean, there's no evidence before you that Mr. Al Tamimi pays money directly to the companies. You'd expect to see his bank account and the company's bank account and a transfer. But I take no point about that. The loan agreements are shams. The loan agreements are shams because Mr. Al Tamimi was shaking hands with himself.
Yes.
He was telling someone he had no authority to tell to enter into a loan agreement for him for a company in which he had no interest. It's fraudulent conduct. I'd invite you simply to read rather than listening to me for any longer. I'm sure everyone will like to stop doing that. From page 227 to 228 of the, sorry, 229 of the bundle that's behind tab 5. That's Mr. Blakely's skeleton argument where he sets it out. It can be summarised in this way. It was just a scramble by Mr. Al Tamimi to try and gain some control over these companies in circumstances in which the power of attorney, he'd been panicked by the fact that the power of attorney had been revoked. So he's tried to constitute himself a creditor. He then tries to petition in London. The petition fails. He issues here instead of simply raising it before the Royal Court in Jersey. And my learned friend says, oh, this is an allegation of fraud. Well, yes, it is, and it's not advanced lightly. If you read the judgment of the Jersey court, there are some damning findings about Mr. Al Tamimi.
How many so far the shareholder in those two companies?
Sorry?
The shareholders in those companies are just two persons, Al Tamimi and...
No.
How many of them?
No. Ms. Al-Chama, this is the key point of the Jersey judgment. When the companies were set up off the shelf, there were some nominees in Jersey, in the usual way, who were shareholders. But from the very beginning, this is a key finding of fact in the Jersey court, the only sole absolute shareholder in both companies was Ms. Al-Chama. And the key passage that you need to read, Your Honour, from the judgment is 68 to 66, paragraph 68 to 66, and that's on page 55. And that deals with an email sent by Mr. Al Tamimi to Ms. Wunsch saying, well, the court interprets it to be intending to mean, just quietly and discreetly be sure that the two companies which own the two flats in London, I am the only beneficiary. Make it a simple instruction to the Jersey trustee, please. And the court sets out two possible interpretations. One, which is that it's consistent with him always having been the beneficial owner. And two, it's an attempt to rewrite history in effect. And it found against him and for my client on that fact. So that's 66 to 68 of the judgment. So in respect of resolutions, she had power. She has power to change the articles. She had power to appoint herself director. I accept that Ms. Wunsch didn't know until the 1st of May 2015, but because of the revocation of the power of attorney, that point goes absolutely nowhere. Thank you, Your Honour.
Thank you very much for both of you, and unless Tom, just quick.
One thing I'd just like to say first is just this. It was the allegation of material non-disclosure was raised. It wasn't raised in the submissions before to say that it was an abuse. To have a material non-disclosure, you need an obligation to disclose. So material non-disclosure arises where you make an ex parte application There's no ex parte application. You have a request, you have a claim form, and then you have there's no application to service out, and then you have a request for default judgment. So it's goes.
All right, well noted. Thank you very much for both of you, and we'll give it in due course. Cheers.
Thank you.
All rise.
Well, I had thought, I think, your side says, which I have some sympathy with. Yeah, I thought, and I know the court's got, thank you, I know the court has got a full day free next Sunday, so I thought it might have arrived, so I will. I'm still around, yeah. It's also my first time in UAE, so I thought I probably should. Yeah. Appreciate that. That'd be great. Yeah.